Recorded live.
Well, hello everybody. Tonight is Thursday, January 27th. We've got a very special guest speaker on for tonight. We're not going to refer to him by his name. We're going to call him Constitution Man or Mike. And are you there, Constitution Man?
I sure am.
Hallelujah. It took a long time to get everybody on the call, but we're here. And we've got Truth also. Hi, Truth.
Greetings. How are you?
I'm fine, thank you. I'm so glad you guys made it on. So, Constitution Man, what are you going to enlighten us with tonight? Everybody is so excited that you're here.
Well, the first thing I would like to do is I would like to pay a little tribute to all of America's finest. We seem to forget about them a lot, and I want to make this dedicated to all of the fine soldiers, sailors, Marines, airmen, and Coast Guardsmen, and we don't want to forget the nurses and the guys that push the carts around and the doctors in the operating room either. I think these people have done such fine work and such greatness, we can never pay them back enough. And so whatever chance I get, I always want to send praise to them, for they are the best by test. And I definitely want them to know that we will never forget you for what beautiful things you have risked your life for, that they do mean something, and that there is a constitutional republic here only because you guys had the guts to go out and do it and stand firm, rain, sleet, hail, or snow, and go do the jobs and whatever it took in whatever god-awful place it was. And that, we seem to forget you guys a lot. We need to remember. We need to remember seriously your donation. So God bless and keep you safe. And we welcome you home for those of you that came home. And those of you that didn't, we pray to God that He puts you in a special hallowed place. So that is the first thing I would like to do, is do that in remembrance. The second thing I would like to do, the second thing I would like to do is try and format this into main issues. And of course, we are a constitutional republic, and all of history has been well documented to that effect. And the problem is that a few absconders at the top have gotten this idea that it's an old document and that they aren't bound by it. When I first came on your program tonight, I heard a gentleman discussing that the Supreme Court had recently ruled that judges can uphold the Constitution or not uphold it as they see fit. Well, I beg to differ, and I will give you the two court cases that matter. One of them is Owens versus the City of Independence, Missouri. That's recorded at 100 Supreme Court, 1398. That's Owens versus the City of Independence, 100 Supreme Court, 1398. And the other is Maine versus Thibodeau, Thib as in boy, Itout. And that's recorded at 100 Supreme Court, 2502. That's 100 Supreme Court, 2502. Now, these cases came down in 1982. They basically had the statement that you are an expert on the law, Judge. You are deemed to know the law and sworn on sacred oath to uphold the law. You certainly can't claim ignorance of the law, because I, as a citizen, can't claim ignorance of the law. That's not an excuse. So it makes the law look stupid when you get up there, a Juris Doctor, and claim to be ignorant of the law. And if you knowingly violate somebody's constitutional rights, hey, you're liable. There's no judicial immunity for that. So when these people tell you that judges can't be held to the Constitution, they're not correct. We need to correct that kind of data immediately and give people the proper data so they can go out and hold these judges' feet to the fire. And if they aren't going to honor their oath of office, we're going to go get their bond. We will make a complaint against their oath of office. We will haul them up before the Judicial Tenure Commission. We will make their life a living hell if they don't honor their word, their sacred word. That's what that's all about when they raise their right hand before God. It's supposed to be a sacred word that they're going to uphold the Constitution. All we're asking, judges, is that you do that. And if you do that, you and I will get along great. If you don't do that, I'm going to be on your tail feathers like you wouldn't believe. So we as a people, every one of us out here, are responsible to make sure we go out and we hold their feet to the fire on this Constitution. Unfortunately, we don't have enough of us doing that, and that's the problem. That's why these guys think they can get away with this stuff. The second thing I need you to know out there is, who are you people? Who Who are you people? You're the Americans. I went into court one day, and the judge says, well, what group do you represent? Who are you with? And I turned to him and I said, we're with the Americans. Maybe you heard of us. We never quit and we always win. Just ask Johnny Wayne. And the whole court broke out laughing. And when I left, the judge said, have a good day, Americans. I says, you better believe it, and we're going to be around for a long time, so it'll probably be a good idea for you to get along with us and try and uphold our Constitution. Now, I know that sometimes I come on a little hard, but the bottom line is what has been sacrificed here so that we can have the privilege of even discussing it here tonight is vitally important. And we need to take it more serious. We need to make sure these people understand we are deadly serious. Now, how can I do that? I have to get that knowledge across to each and every one of you out there in TV land. You see, Benjamin Franklin was right when the news people confronted him coming out of the Constitutional Convention. So what do we have here? He turned to him and said, we have a constitutional republic if you can keep it. But then the key is on you. Can you keep it? And see, we've kind of fell short on that. Can you keep it? And that's our responsibility. And we have to turn this around. We have to demand our rights. The only way you have rights is if you know those rights. You be the belligerent claimant in personam. That means you're the one. That means they're my rights. An attorney cannot save or claim your rights for you. As a matter of fact, an attorney's first duty is to the court. I'm sure there's a lot of people out there that don't know that. There's probably a lot that do. But an attorney's first duty is to the court. And when you get an attorney and walk in there, you're waiving your rights. So we need to correct that. We need to get you knowledgeable so that you know unequivocally, without doubt, what your rights are. And our status today is we have put this off on congressmen and congresswomen and municipal administrators and all this stuff, and when you check those guys out, they don't know their rights either. So we have a double problem here. And we have to just fix this. Nobody's going to fix this for you. You cannot sit down at meetings pretending like something is getting done just because a bunch of people showed up in a hall. You'll notice if you watch the clock after a while that not much is getting done. Everybody means well and everybody is mad, but not much is getting done. So what you got to do is say, hey, I'm a somebody. Why don't I go out and do something as a somebody? You hear people say, somebody ought to do something about this. Well, hey, you're a somebody. Go do something. The name of the game here is it's our country, ours. All these people that talk about them taking over our country, you better quit smoking that stuff. It's not any good for you. There's a whole lot of fine soldiers here that would take issue with that and would fight to the death. We're not letting you take over the United States of America. Actually, these United States of America. Thus, the corporate. These United States of America. Probably be a real good idea if you figured that out sooner rather than later. So let's get down to brass tacks. We want to put it back the way it was supposed to be, the way the forefathers intended, the way it says in the Constitution under 16th Am Jurisprudence 2nd, Section 97, that the Constitution is supposed to be interpreted to include every word, every phrase, every syllable, to include the punctuation, to include the intent of the framer, the guys that actually sat down and wrote it. That's Cohen versus Virginia, 62-1821. It says that is the intent of the law. And then after you've figured all that out, you're supposed to turn around and enforce it liberally in favor of us, the people, who are the beneficiary of the contract. So we got a right to be wrong, but we don't believe we're wrong. I want my rights now. I want my right to keep and bear arms now. I want my right to travel now. Shapiro versus Thompson, 394 U.S. 16 says the right to travel, such basic right, don't even need to be mentioned. So why are all these states issuing driver's licenses to travel? And the law says by the Supreme Court in Murdoch versus Pennsylvania, 319 U.S. 105, no state may convert my constitutional rights into privileges and then in there require me to have a license and a fee for the exercise of the right. And if they do, Shuttlesworth versus Birmingham, Alabama, 373 U.S. 262 says I can ignore the license and the fee and engage in the right with impunity. Now the Supreme Court has ruled
slow down a little.
The Supreme Court has ruled further in Bishop, U.S. versus Bishop, 412 U.S. 346, 412 U.S. 346, that if I rely on the advice and counsel of 9 justices of the Supreme Court of these United States, I have a perfect defense to the element of willfulness. Willfulness defined as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. That means that prosecutor couldn't prove this case on the best day he ever lived, Judge. Therefore, he don't have a cause of action for which relief be granted. And I'd kind of like the motion to dismiss failure to state a cause of action. That'd be Michigan Court Rule 2.116, friends C, friends 8. And I'd kind of like my costs and fees to entertain this patently fraudulent and spurious complaint, Your Honor. May it please the court. And then just shut up. And all of a sudden, the court will just erupt. All the attorneys there that watch you get hung will just bust out laughing. And the judge will turn and say, well, Mr. Prosecutor, what do you think we ought to do? Would you venture a response? And the prosecutor would get up and say, well, Your Honor, in consideration of the argument, I believe we're going to have to dismiss this one. And the judge will say, good answer, because I don't think you're going to beat this kid today. I kind of think he'd go right through the middle of you like Grant went through Richmond, and you would have smoking tail feathers. And all the lawyers will stand up and cheer, my God, did you see that? He just busted the Bar Association with practicing law without a license. How did he do that? Because he has a right to work and contract his labor, his skill, and his time of life. That's Bailey versus Alabama, 219, U.S. 219. Now, if it sounds like I'm overwhelming, I apologize. But I want you to understand, I am not an attorney. I don't claim to be an attorney. I have passed the bar exam with 98% correct answers. But I didn't take the license because I didn't want to be a party to the adhesion contract, because then they could come and tell me, you got to let this guy lose. He's going against the state. Either let him lose or we'll pull your ticket. See, and I don't do that. You don't come and tell me who I'm going to let lose or let win. If I tell somebody I'm going to protect them, then by God, I protect them. And don't come in my office and tell me I got to let this guy lose because he's going against the state. I don't want to hear that garbage. Just park your ass out on the street someplace else, not in my office. Now, to make a long story short, I've been in this battle for over 42 and a half years. This is my 42nd and a half year. It'll be 43 years, June the 17th. I've been helping every little person get their day in court as best I can within my limitations and my resources. I know what these guys are doing. And I'm telling you as a friend, we have got to do better, and we have got to get on top of this, and we have got to grab these people by the short hairs and let them know, hey, this is not flying here in these United States of America. This is America. Last time I checked, there's a red, white, and blue flag out there on that pole. I'm not talking about the one with the gold fringe on it. That's an admiral's flag. That's not my flag. My flag is the red, white, and blue one. And these colors don't run, pal. So you want to get in a fight, come on down. Because these colors are going to stand tall till the sun falls out of the sky and the rivers run dry. Now, let's just get down to basics here and let these people understand we, you, me, everybody, the people are not having any of this takeover stuff. We're not having it. We're not having any of this tearing our Constitution down and throwing it in the sewer. We're not having it. So probably be a real good idea if you put your best thinking cap on, get your pencil sharpened, and let's sit down and try and put it back the way the forefathers intended. And then let's let that benevolence roll down into the people so they can have confidence in our ability to manage our affairs intelligently, rationally, and in a decent Christian manner. Now that's my goal. And I teach every single person I can, everything I can, to make sure that they can walk in and claim their Constitution and their rights. And I've had many of them in tears walking down the aisle of the court on the way out of the court. I had this little gal, and she beat the best attorneys they had in this one little town. And she said to me, hey, Mike, I think I got my dignity back. I said, yes, you did, baby. You whooped them bad. They ain't never going to talk about this again. You whooped them real bad. And I said it loud enough. They wouldn't even look in her face. Tears running down her cheeks and everybody cheering. Now, see, that's part of my pay. When I see that, justice has been done. And every one of you out there in TV land can do this. You just got to apply yourself and get rid of that word can't. Can't is not a Ranger word. Never is not a Ranger word. We don't even have those words in the Rangers. Quitters never win, and winners never quit. That's our motto. And strike like lightning, sound like thunder, day or night. That's our motto. We're not going to fool with you. We're going to knock the snot out of you and turn around and do it again just so you know next time we ain't playing. So probably be a good idea if you just fixed it. Put it back the way the forefathers wanted. Go grab you a Federalist paper, start reading. That's the clear intent of the framers of the Constitution when they made it, okay? And that's by Madison, Hamilton, and Jay. Go pick up that book, The Federalist Papers, by Madison, Hamilton, and Jay. And start reading that thing upside down and other. And then you're going to start realizing, hey, the Second Amendment says a well-regulated militia being necessary for a free state. That's just common sense. If I told you oranges are orange, that's why they call them orange, you would know that I was telling you the truth, right? But that doesn't have to do with the right. What has to do with the right is when it says the right of the people to keep and bear arms. That's the right. And whenever the Constitution says the right of the people to keep and bear arms, they mean the right of all the people, each and every one, not just the judges, not just the buddies of the sheriff. All the people have the right, no matter what, race, color, religion, ethnic background, or where they happen to drop out of their mama. The reality is all people, the right of the people is an individual right of each and every person to keep and bear arms. Shall, that means must, not be infringed. Infringed means to steal stealthily by encroachment. Now, I look at these laws, and every time I look at these laws, I look and I say, what is this guy talking about? And they say, well, we have police powers. Police power is the right of eminent domain of a state or political subdivision to enact laws for the common good and welfare and to curb crime. And then in great big black bold letters it says, within constitutional limitations. Bingo. See the 10th Amendment, it says. Okay, so I saw the 10th Amendment. The right of the people, the rights declared in the Constitution to the federal government are those that are guaranteed. And the rights not so granted are those for the power of the people in the state. Okay? Now, that are not prohibited, it says. That are not prohibited. Well, guess what? That Second Amendment that says, and that right shall not be infringed. Does that sound like a prohibition to you? It's prohibited. So how come these people are messing with our constitutional right to keep and bear arms? Why? Have they taken a look at the country of Sweden and seen that all male citizens are required to have their stuff, their kit, their rifle, whatever have you, and be ready to move on a moment's notice to protect the republic? Huh? There's where the militia comes in. There's where defending your turf comes in. And they're right. A well-regulated militia is necessary to maintain the security of a free state. So that's just a true statement, right? Kind of like oranges are orange. But the real issue is the right of the people to keep and bear arms shall not be infringed. And I'll tell you folks, especially you Michigan folks and Ohio folks out there, you start looking in your state laws under your 75227, which is your MCLA gun rights and concealed weapons carry rights, and under page 755, Notes and Decisions, paragraph 3, it very clearly says the legislature cannot deprive a constitutional conservator, that's anybody who ever raised their right hand and swore they protect the Constitution, from piece of right to carry a concealed weapon. And that's right in the concealed weapons law. The legislature cannot deprive a constitutional conservator piece of right to carry a concealed weapon. And when I brought that up in court, they couldn't believe it. Then I took the book right out of the law library up on the 12th floor and brought it back down and showed the judge. That's exactly what it says. He was shocked. They had to let me go. I'm telling you, Steven Seagal is right. Chance favors the prepared mind, but he's not the first one to say that, but I know he learned it from very serious Oriental theorists, okay, but it's true. Chance favors the prepared mind. So if you want to win this stuff, you got to get off your tail and go down to that library and start cracking some books and start looking through these things. You would be amazed the things that you could find. It would shock you to death. One day I was reading through the law books under Title 31, Section 742, and I saw the statute, and I said, wow, is this saying what I think it's saying? It says, except as otherwise provided by law, all stocks, bonds, treasury notes, and any other obligations of the United States. In case you haven't checked, look at them green things in your pocket. It says right on it, obligations of the United States, okay? It says, except as otherwise provided by law, all stocks, bonds, treasury notes, and any other obligations of the United States are exempt from state, municipal, and local taxation. This exemption extends to every form of taxes that would require that either the obligations and green things in your pocket or the interest thereon, the way they do your property taxes, be considered directly or indirectly in the computation of the tax. And that was upheld all the way to Memphis Bank versus State of Tennessee, Ed L. Garner, which says that's the supreme law of the land. Well, guess what they did? They went in the law book in every state in the Union, and they moved Title 31, Section 742, without putting any repealed, revised, or otherwise changed or removed or moved to, and they put it at Section 3124 in the back of the book. Why? Because they didn't want nobody to ever find that again, because that took away all states and every state in the Union's right to tax any everything that was based on obligations of the United States. Now, what does that do for your property taxes? What does that do for your employment taxes? I mean, when you have this kind of knowledge, all of a sudden, my God, oh, they don't want to talk to you no more. Oh, just go away. Oh, okay. And then you don't get bothered because knowledge is power. And having that knowledge can help you get your serious day in court. Without that knowledge, you're just like a piece of paper in the wind, and they just do what they want with you. And they tell you you don't know, you're not an attorney, you don't know nothing. I don't even have to talk to you. Da 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 da. Last time I checked, we were the boss. Now, I don't know if any of you out there have ever worked a serious job, but you're going to find on the wall on a serious job, issue number 1, the boss is always right. Issue number 2, when the boss is not always right, see Rule 1. Now, the last time I checked, we were the boss. We need to start telling them, see Rule 1, buddy, we're the boss. I want you to fix it, put it back the way the Constitution said. And I don't want to hear no ridiculous malarkey or any other frivola. You just fix it, and we'll get along fine. You don't want to fix it, you're fired. We'll find somebody who can honor their oath of office and keep their word of honor. If you don't want to keep your word of honor, you don't want to keep your oath of office, you're fired. And by the way, we're attaching your bond. And we're suing you. And we're going to charge you with treason against the people and government of these United States. That's Title 18 United States Code, Section 2381 through 2384. Now start reading some of that. You'll be shocked. If in the presence of 2 witnesses to the same word act or in an open court of law they fail to uphold the Constitution, they are subject to the charge of capital felony treason, and upon conviction they shall be taken by the posse to the nearest and busiest intersection and hung by the neck till they are dead, dead, dead. Now that's what the law says. And I read that to a judge one time and his face turned purple, but he knew I was right. Now am I to understand today, Your Honor, we're not going to uphold the Constitution? Is that what I'm hearing? No, I didn't say that. Okay. We'll wait for your judgment. But I'm expecting an acquittal. Now, I love all of you out there. I know you love America, or you wouldn't even be here. Let's get on the job here, folks. We need to do something big. We need to send a message to every swinging joker in any position of authority, hey, you need to get with the program. If you aren't going to do that, we got to replace you, and that's just the way it's going to be. I remember the day we voted to give Sheriff Mack his book on Anderson on sheriffs. What we would do is take a percentage of every meeting that we would have every other week Wednesday, and we would take the room. We would ask for donations in the room to help us pay for the room to put the meetings on. And then a portion of that we would take out and we would buy the book Anderson on Sheriffs, and we would distribute it to sheriffs. And I remember the night we voted to distribute it to Sheriff Mack. And now look at Sheriff Mack. Sheriff Mack is an informed sheriff, and he's going everywhere. And he's holding their feet to the fire. And he's teaching other sheriffs the real reality of sheriffs. See, little people can be very effective. And you never know how effective until you try. But you have to try. Do something. I don't care if it's a little thing like mailing a book on sheriffs, a book to the sheriff and telling them, this is your real power, sheriff. You're the head guy in this county. You need to understand your powers, and you need to understand you don't have to take second seat to nobody. And if you're finding these people are violating your rights, hey, lower the boom on them. Let them know they come in your county and do this stuff. They're going right to you're going to be a guest in your Crowbar Hotel because you ain't having it. And the more people we get lined up and locked in on this, sooner we're going to get this fixed in a rational and peaceful manner, and that's the goal. We don't want a violent overthrow. We don't want a violent insurrection. We want them to just realize all of a sudden, look on the page, see where we're at. Hey, we need to fix this. Oh, okay. Why don't we just fix it? Oh, that'd be really great. Do you think you could do that by the end of the week? We'd really appreciate it. And see, people that are in powers and in authority, the sooner they would come to that reality, the sooner we could get back to a happy, happy America, a prosperous America. We would probably advance our society at least to light speed. I just can't encourage people enough to put your thinking cap on, come up with some ideas. Let's get these people in office knowledgeable so that they can better protect our rights, okay? And that's our responsibility. We have to do that. That is our responsibility. So I'm encouraging you to go out there, put your thinking cap on. Let's come up with some ideas. Let's try and involve these people in some dialogue. Let's try and let them understand, hey, we're not a bunch of kooks drinking beer in the woods shooting pop cans and stuff. We're really good guys. We really love America. We want America strong. We don't want anybody thinking they're going to come over here and take over. They're just foolish children. Their mama raised stupid kids. Nobody's coming over here taking over nothing. That's my basic position on this. I'm encouraging you to go out. Let's get on top of this. Let's do something to fix this. I don't care how small or how big, but if they have these saws, they're called hacksaws. You notice the teeth on the hacksaw are just little bitty things, little tiny things. But you know something? Those little teeth each grab something, and when they do, they cut the heart of steel. Why? Because everybody's getting online, and everybody's taking care of business, and everybody's taking a little piece of this, a little piece of that. And the next thing you know, that steel bar is cut right in half, right? All right, I want us to start thinking like that. And everybody, come on, put your thinking cap on. Let's figure some way each of us can go out and grab a little piece of this, and let's fix it, especially for our kids and our grandkids, because they're going to inherit god-awful what if we don't take the bull by the horns and let's get this done. That's my best counsel to you as a friend and as a serious American. They don't think we're smart. They actually published a book, and it's called Silent Weapons for Quiet Wars. And in that book, they published that we're just beasts of burden and steak on the table by choice and consent, or trainers of the same, and that we'll never be smart enough to swim the moat of ignorance and figure out what's going on here. Well, folks, surprise, surprise, we swim the moat of ignorance backstroke. We don't even fool around. So now that you figured out that we're pretty smart, every time you bust your shoe, you take it to a shoemaker to fix. You bust your watch, take it to a watchmaker. You bust your teeth, you go to the dentist, right? You bust your heart, you go to the heart specialist, right? At what point do you people think at the top that we got stupid? We can do everything. You can't do nothing. Every time you mess up, you got to come to us to get it fixed. We're the ones that put the rocket on the moon, not you. Now, come on. Figure this out. Okay, you got a cushy job now? I'm going to tell you what. We're going to put the burden on you now to come up and fix it the best you can, or plan on leaving office, because we are not going to have you in there deliberately sabotaging our great republic. So probably be a good idea if you put your thinking cap on too and try to figure out what we can do in the next week to fix this better, so we don't get crazy kooks like that guy in Arizona going out doing stupid stuff, hurting innocent people. We don't have people just walking into police stations shooting the place up. That's stupid. Why would you do that? The bottom line is we want people to go down to the library, look up the damn case, look up the law, and go to court. Hey, Your Honor, may it please the court, I'm hearing before you, pursuant to Article 1, Section 13, Paragraph 5, I've appointed myself my own attorney, and I'm ready to proceed with my administrative and procedural matters. And at this time, Your Honor, may it please the court, I motion to dismiss this case for patently fraud, spurious complaint. There's no fact or general issues of material merit. I move to dismiss or summary judgment pursuant to MCLA 2.116(c)(8), and I'd like to collect my costs and fees rather than this patently spurious complaint. And the judge will roll his eyes back, flip his pencil in the air, and he says, there couldn't be two of them guys. Or it's actually happened to me. All the prisoners that were handcuffed in the jury box waiting arraignment stood up and says, I want him for my attorney. And the judge, well, you can't have him for your attorney. He's not an attorney. I don't care. We want him. Well, that's actually happened to me. So I'm telling you, you can do this. Don't let I got old ladies that drive trucks that can do this. I got old guys that dug ditches that can do this. I got all kind of people, youngsters. I've got a young kid today that walked in and just slammed the hell out of him on the right to keep and bear arms. This can be done, but it takes serious people with drive and tenacity and serious courage to stand up there. And I told this big motorcycle guy one day, he came in, beat the hell out of 8 of the guards, wiped the floor with him. And they threw him in with me, and I cleaned him up and used toilet paper and the water from the sink. And I says, I says, you're really a bad dude, you know, and I mean, I saw you wipe the floor with 8 of their big guards, but see, they get you down with one of them tasers, and then they beat the holy hell out of you, you know. You're not going to win like that. If you want to win, you can't curse nobody, you can't beat on them, you actually have to be a perfect gentleman. See, if you're a perfect gentleman or lady, then they know you're a person of breeding. Then they got to listen to you, because they respect themselves as a person of breeding, and a person of breeding has to respect another person of breeding, and then you get to say your whole enchilada. And see, when you do that, and I says, now here's what I want you to do. You promise me you can't curse nobody, you can't beat up on nobody, you got to be a perfect gentleman. I says, I'll do your papers for you, and I'll teach you exactly what to do and say. I says, but you got to promise me now, you're not going to go down there and just be a jerk, okay? Also, when you're done, I want you to go over to one of them there magazine shoppes, and I want you to buy 2 dozen of them Sports Afield swimsuit editions, and I want you to send one to every floor in this jail, got me? Because if the boys are looking at beautiful girls, they ain't got time for fighting. And then the sheriff can't send in all those black-helmeted guys with sticks and beat the hell out of them. And sure enough, he walked over to that judge. Your Honor, may it please the court, I'm so-and-so. I'm here appearing in Article 1, Section 13, Paragraph 5, in appropriate persona as my own counsel. I'm ready to proceed with my administrative and procedural matters. And at this time, Your Honor, may it please the court, I move for dismissal with prejudice, failure to state a cause of action upon which relief me granted. And I kindly collect my costs and fees. That'd be Michigan Court Rule 2.116, C, parens 8. And that judge rolled back and says, there couldn't be 2 of them guys. And the whole court just busted out laughing. Mr. Prosecutor, have you seen these documents? Yes, Your Honor, we've seen these before. Believe me, we've seen these before. And we know exactly who did it. And we're going to have to let this guy go, so we're going to drop the charges. So they let him go, and he came back to the jail like Rocky with his arms in the air, bum, ba-da-bum, 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 you know. You did it, Pops. You damn well did it. You damn well did it. We won, and they got to let me go. I said, all right, you remember your word now, and don't forget to go get some good-looking magazines and get them into every floor in this jail. I want every one of them prisoners to be not getting their head beat in by some black-helmeted guys with nightsticks, you hear? Let them sit down and mellow out, look at some beautiful girls, and get out of hock. Sure enough, man, that sheriff was so mad when I left that jail, he told me, don't never come back here, Pops. We don't never want to see you again. That is what can happen if you apply yourself. That's what I'm asking you to do. Go apply yourself. Let's let these guys understand who the hell they're picking on. You're picking on Americans, pal. And when they ask you, well, what club do you come from? Who do you represent? Tell them, we represent the Americans, Your Honor, may it please the court. Maybe you heard of us. We never quit, and we always win. Just ask Johnny Wayne. He'll tell you. What are they going to do? Go ask John Wayne, the Americans don't win? Come on. Well, it's time to get real, folks. I'm putting it on you. I'm putting it on you hard tonight. I want you to go out there. I want you to put your best thinking cap on, and I want you to come up with good ideas, especially in communication, on how to get to these guys, how to effectively get them to understand where we're at, what we're trying to do. I'm asking you to help every little person out there that's getting railroaded. A lot of people out there are getting hammered.
I was going to ask you, what do you do if you're in a foreclosure situation with all these false and fraudulent documents that the banks are filing in on these folks?
All right, I will give you the exact procedure so that you can do that, because we are hot and heavy in that right now. I'm in several Supreme Courts. I'm in the Federal District Court. I'm in the Wayne County Circuit Court. I'm in a bunch of courts in Ohio. The first thing you have to do, first of all, is we have to get a copy of the file. Okay, and almost you're going to find there's a tremendous amount of people that signed documents that never got copies of them. That was a real shock to me. And then when you go ask for the copies from the people that are claiming to be the borrower or the lenders, all of a sudden they get real quiet and they don't want to give you no copies of the original file. When you start checking through the copies of the original file, you're going to find glaring errors. One of the errors that they've been making that's real bad, that's been highlighted all the way to the Massachusetts Supreme Court just recently, 2 weeks ago, there's a case called U.S. Bank and Wachovia Bank versus Ibanez, I-B-A-N-E-Z, and it just happened a week ago Friday in the Massachusetts Supreme Court. And in there, the Supreme Court held the bankers to the standard of their constitutional standing. On what standing do you have when you come before this court? And, of course, if you're not the actual note holder, and if you want to look up some references on this, you want to look up Uniform Commercial Code.
Go back and download
Uniform Commercial Code 3-, 3-202 parens 2. That's 3-202 parens 2. And you want to look up 3-203. Now those are the actual situations which prove a holder in due course. You also want to look up 3-405. 3-405. So you have to be a holder in due course. Well, do you have the note? Well, no. Wait a minute. You said you were a holder in due course. Where's the note? You can't separate the note and the mortgage, because once you do that, you have just non-collateralized that loan. And see, when these guys are going out and they're going under the table and they're handing these notes from bank to bank to bank, on assignments, and by law, they're supposed to notify you within 3 days of an assignment so that you got a right to rescind the contract if you so choose to do so. And they don't do that, so that means that they've extended the time to a year to rescind the contract, okay? Also, you're going to find that on a lot of these affidavits that they've signed to verify their claim, they're signed by these robo-signers. One of these guys for Chase Banks swore under oath that he signed 5,000 affidavits in one day. How could you examine 5,000 files and completely said that you understand the file, or you have gone through the file and understood the file, and you've signed it 5,000 times in one day? Come on. We actually found one of these signers was all the way back to 1936. Well, shoot, they'd be almost 100 years old. How could they be there to sign? They couldn't. Now, these are the errors that you want to pick through and find. Also, you want to ask for the receipt for the origination fees. You paid an $800 fee for an origination fee receipt when you did the closing costs. Well, when you go look up that original receipt and find out where'd you get the money to do this loan. You see, the bank can't loan money. The bank cannot loan out its constituents' money because that would be a breach of ethics to that person because they're supposed to guard that money. What the banks are lending is their political, financial influence. They're influence peddling with electronic banking figures which don't cost them nothing. So when they enter a contract, for a contract to be a lawful contract, there must be a genuine offer. Check. You're going to find out a lot of these banks ain't even licensed to do business in your state. So there couldn't be a genuine offer because they're not a licensed bank to do business in your state. There has to be a valuable consideration. They're not given an equity valuable consideration. You're pledging your actual life, blood, sweat, and tears to give them a real value, and they're not pledging nothing but electronic book entry notes that don't mean nothing and have no value. So we don't have a consideration. Did you knowingly enter into this contract where everything was told to you exactly what was going on? Hell no. That never happened. You did not get full knowledge. And did you sign the thing voluntarily with full knowledge? No, you didn't sign it with full knowledge. So you couldn't have a contract. There is no contract. This is all made up frivola. These guys have been getting away with this stuff for years and years and years, only because we have not paid attention. Now, immediately upon checking into your mortgage, you're going to start finding out there's a lot of errors. Some of them have assignment contract requirements in them, and some of them don't. So when they assign these things, guess what? They broke their own contract. Look in the contract, see if they have a right to assign it, okay? And see, I actually had one woman that actually entered into a contract with this mortgage company only to find out that the bank had changed the contract from a non-variable mortgage to a variable mortgage. Well, she didn't do that. She wanted a fixed rate mortgage. Well, then it came back it was a variable mortgage, and they were allowed to change the interest rate. Come on. That's absolute fraud. You didn't sign to that. Where did I initial that? I wanted a fixed rate mortgage. You put me in a variable rate mortgage. Now, once you have discovered and you have written letters and tried to work with these people, I'm telling you they're going to stonewall the foreclosure immediately. They're going to try and not respond, not take care of business, not write you back. You can ask till you're blue in the face. The important thing, though, is that you have a history of sending them at least 3 to 5 letters explaining that you have tried to get discovery from them and that they wouldn't comply. Then you have to send them a letter telling them, hey, if you're not going to comply, I'm going to have no other recourse but to sue you. Now we have a litigation possibility going here with a lis pendens. Look in most state foreclosure laws, a foreclosure by advertisement. There can't be any civil litigation pending, period. In Michigan, that's 600.3204. And when you look up the 600.3204, it says that they can't have any litigation or any legal entanglement pending. to have a sheriff's sale by foreclosure by advertisement. So they broke that. We went and one sheriff found out he didn't even take his oath of office, so he couldn't be the sheriff. So how could he swear in a deputy sheriff? He couldn't. So when they had the deputy sheriff do the foreclosure sale and sign the sheriff's deed, was that a valid transfer of property? No, it was a fraudulent transfer. We pinned their hide on it. It's now in the Michigan Supreme Court. There's all kind of ways to fix these guys on these foreclosures. Now let me tell you a top secret. These guys, in their cleverness, assuming that they were going to cut somebody out of a piece of the change, they decided to cheat all of the recorders for the local recording offices and deeds, records and deeds offices, and they formed themselves a MERS company. It's a Mortgage Electronic Registration System. And if you check it out real close, you're going to find out companies like Trott & Trott are 50% owners in this MERS corporation. So when they tell you they're just a service contractor being the attorney of record on the case, they're liars. They're actually partners in the taking of this property, and they have a financial interest in the outcome. Now, MERS is supposed to be a nonprofit corporation, and in their bylaws, they can't own any property. It says so. Call up their bylaws on the Internet and check them out. You'll see I'm right. They can't own any property. So when they transfer the property through MERS, they're trying to cheat the local records and deeds offices out of their recording fees for having sold the property and recorded it as sold. They're also cheating the tax man out of getting his tax because they need to know who actually owns property now for tax purposes. Well, they deliberately hide that so that you can't find out. So then who do they bill for the taxes on these properties? Well, we don't know. You have to get a hold of MERS on their computer. But what they failed to realize when they were doing all this scamming is when they ran it through that nonprofit tax organization, they canceled the chain of title. And without that chain of title, they have no standing to come to court and say, hey, we're now the new owners based on it was assigned to us, and it came through MERS. Bingo. Well, how did MERS transfer it? They can't own nothing. Whoops. Uh-oh. And now 62 million people that are being brought into foreclosure may find out their foreclosure proof by the fact of knowing that MERS can't own any property, so they couldn't assign or pass through any property through MERS. You go online and you look up MERS, and you're going to find a whole bunch of this kind of data. Go online and look up rents, RENSE.com, and look up things like 4Winds, 4Winds.com. You're going to find all of this data on how these foreclosures are illegal, all about these robo-signers. These people are signing millions of documents every day. They haven't even looked at nothing, and they're swearing affidavits. Now, they've passed laws in Florida and New York that if a lawyer gets caught passing off any fraudulent documents, that they will be immediately suspended and that they will have to defend their bar license and possibly go to prison for putting fraudulent documents before the court. That's happened in Florida and it's happened in New York. It's going to come this way. I can tell you the Attorney General in the state of Ohio is absolutely livid. He's investigating these real estate deals really big. And the Supreme Court is very friendly in Ohio to people that are trying to get their foreclosure rights. So Michigan is going to be right behind them. But Michigan, as you know, is very, very heavily in foreclosure now. If you saw the paper 2 weeks ago, it had to be at least 2 inches thick of all of the foreclosures here at Christmas time. And I'm hoping that one of my cases is going to kick in, and if it does, we could get some honest judge to all of a sudden issue a moratorium. Now, we had an honest sheriff do it, a guy by the name of Warren Evans. And all of a sudden, on February the 4th, 2009, he came out and said, hey, we're not doing foreclosures anymore. It's not honest. Now, we went and tracked down that record and found out that his attorney had advised him not to do foreclosures because they were in direct violation of the federal TARP and TILA laws. Those are your truth in lending laws, and that they're supposed to send you an affidavit that they sat down and tried to help you redo this mortgage so that we could try and save this one, okay? And, of course, Obama put $179 billion in a special fund to go to these banks if they can prove that they really try and help these people on their foreclosures. So a lot of these banks are now bending over backwards to try and help people, but I'm telling you, it's been my experience to date that the bankers haven't been real honest about it. They just go through the motions so they can get some paperwork to show the government to collect the $179 billion funds, but when it really push comes to shove, they don't help the people. They just blow them off and let them go down the sewer. So these are some things that you can do in battling these foreclosures. Go check everybody that's involved, oath of office. You're going to find a lot of them don't even have one. I was shocked. to find that some judges that were at the Court of Appeals didn't even have oaths of office. Now, how do you get to be a judge without even knowing you're supposed to have an oath of office filed timely within 10 days of your election? And that if you don't have, you're a quorum non judice, which means you're in the presence of a person not a lawfully seated judge. Now you go after their bond at the city treasurer's office. All of a sudden, you can't be serious. Oh, I'm deadly serious. What we got here is a fraud. And I'm going to tell you, Judge, if you don't vacate your judgment here, I'm going to make sure you're off the bench. Now, these are the things that we have to start doing. We have to go get these people, hold their feet to the fire, let them understand, what you think that was a joke when you raised your right hand in the Bible and you said you'd swear to protect and defend the Constitution from all enemies, foreign and domestic. Well, guess what, Judge? You're one of the enemies. Now, why don't you get with the program and start upholding the Constitution? Now, this needs to be done. We need to have it done. You are the ones. It's you. You're the government. When you start hollering about the government, remember, you're the government. Now, what I need to know is, are you a boss or are you just one of the flunky workers? I'm holding out that you're the boss. Okay, boss, what do you want to do? Give me some direction. Tell me what you want. Go down and tell them what you want. I want you to fix it. Now, the sad thing is, we the people here, they come to us. These bankers went out and they did all kind of shaky stuff and gambling on the stock market, and they did all these diversity programs and all of these selling short and buying long and all this stuff, okay? And they burned up a whole bunch of their profit margin, and then all of a sudden they're going belly up. And they have the nerve to come to us, the people, and want us to reach into our pocket when we're so strapped and shell out our tax dollars to bail their hide out so they can foreclose on us twice as fast. What kind of logic is this? Hell, let them go belly up if they're going to do that. They're not helping us. Why would we do something so stupid? You need to call up your congressman and tell them that. Why are we helping these bankers when they're going to put us right in the sewer? You know what I'm saying? That doesn't seem logical to me. Now, they're the ones that created this mess. They're the ones that shortened the supply of money in the system. They're the ones that are trying to claim they're going to balance the budget. What, are they going to balance it on our back now after we bent over and helped them to save their ass? Now they're going to come and throw us in the sewer? I don't think so. Now, what we got here in this famous movie, you go see Cool Hand Luke, what we have here is a failure to communicate. We need to fix that. Now, reality is struck. It's here. It's now. You, the people, are the boss. I want the bosses to start bossing and telling these people right where the line is. You guys are way over the red line. If you screwed this all up, Mr. Congressman, Mrs. Congressman, whatever. We want it fixed, and we want it fixed today. So if it's not fixed, we're going to have to hold somebody accountable, and that somebody's going to be you. So I would encourage you to sit down and look at this, and let's see if we can't come up and put our heads together and fix this. What do you say? Now, does that sound like the rational way to get this done versus having some guys go out and do some god-awful violence that is not going to make any sense to anybody in the end? See? And then, in the end, when we do have this, we'll have a very strong, powerful society. The cancers will have been cut away, and we will have a virulent, strong society that has a clear communication line between their congressmen and their people. And they're going to know what they're going to get away with and what they're not going to get away with, and they're going to know what we will yell at them for and what we won't yell at them for. And also, with the backside of that, we got to praise them when they do good stuff. Like that one judge that got shot there in Arizona. A lot of people don't know it, but that judge was a good judge. He was upholding the law to the black letter law, and he was stopping the government in Washington from trashing the sheriffs in Arizona. And he wasn't having none of it, you see. And Sheriff Mack was one of the leaders on that one, too. And he wasn't letting the government trash these sheriffs because they weren't going to enforce what these guys in these Homeland Defense ridiculous programs were trying to shove down these sheriffs' throats. And he was upholding the standard of that the sheriff is the boss of the county. He is the boss, and you have to give the sheriff his day. Is it any wonder why all of a sudden this judge is shot down? Gee, I can't figure that out. It was an accident. Baloney. That judge was a serious judge, and he was voting on the side of the people. Now, we need to reward judges that got that kind of guts. We need to protect them better so they can't have stuff like this happening. And all of a sudden we got some lone kook, and he's got a big diary that says, I'm a kook, sure, I'm a kook, okay. And he goes and takes a gun and does some violent, stupid stuff. Oh, and then we need more gun control. Like, what happened to the gun control you had in place? That didn't work, did it? Gee, how'd I know that? Let's get real, people. There was a town here in Georgia that passed a law. All male citizens of a certain age had to have their gun. They had a similar town in Illinois, and they passed a law saying nobody could have a gun in this town. Well, guess what? Crime rate in that Illinois town went up 300%. Crime rate in that Georgia town went down to 0. See, smart criminals don't like getting shot. They aren't going to come to your house if you're required to have your gun. But they were taking people out of their sick bed in this Illinois town right while they were sleeping in the middle of the night. And they took their furniture and everything. They cleaned this old couple's house right out. So I'm telling you, the forefathers were not stupid men. They were very smart men. They spent a lot of hard time arguing these issues, and they were pretty smart, and they were definitely God-inspired. When you start studying that Constitution the way I have, you're going to be amazed at the brilliance of that document, that they were that far ahead. You're also going to be amazed to find out how scholarly some of these people, George Washington and Thomas Jefferson, were. They were very well-read men. And they didn't want to start the same crap that was going on in Europe here. They did not want a continuation of that government. They wanted a new and improved government. And they set down about having that as their task. And they wrote it down so we couldn't forget it. Now let's start enforcing it. What do you think, folks? Think that's a winning idea? Let's get on the bandwagon here. Everybody get together. Let's plan on starting going down and collaring these legislators and these government people and letting them understand about their oath of office and letting them understand you don't cooperate and honor your oath of office, we're going to come get your bond. You aren't going to be able to work as any kind of a government office person in the future. You can't get a bond. We need to hit them where it hurts, in their pocketbook. We need to hit them and let them understand we're going right by the book, and we want you to go right by the book, but if you're not going to go right by the book, then you need to understand we're going to have to do something about that. I'm going to replace you.
Mr. Mike?
Yeah.
This is true. Do you feel like doing some Q&As? Would you take a drink of water and let some of the callers ask you some questions?
I will be happy. I kind of get wound up on this stuff because I spent 3 combat tours in a row in the Republic of Vietnam. I saw an awful lot of good men die. And so to me, this is important. This is real important. We can't let them die for nothing. All right, you get your
everybody.
question and answers.
Let me ask everyone, if you'd like to ask him a question, press star 8. Star 8 will put you in line and put your hand up. Did you want to get a drink of water or anything, Mr. Constitution?
I'm ahead of you. I've already done it. Done it. Been to the sink and done it.
All right. I've got a question for you real quick.
Okay.
I'm asking for someone that can't get in there. The line's been busy and it's so jammed up they can't get in. But they Skyped me and want to know. They wanted me to ask you about the coffee bean payment.
Okay.
And is it valid for all states or just Michigan?
Valid in every state in the Union, pursuant to Article 4, Clause 1 of the United States Constitution. Full faith and credit shall be given to the laws of the United States and to those. The case is, it's the
Montgomery
Wards versus Eugene Glacier. It happened around 1984, in October of 1984. I was physically present in the court that day. It was before the Honorable Judge James P. Sheehy, who was a phenomenal judge, who just recently retired with cancer, the poor guy. He was a phenomenal judge, and he had a tremendous sense of humor. And apparently this gentleman was going to get a divorce, and his wife got mad at him, and she took the charge card and went over to Monkey Ward's, and she charged from the front door to the back door and parked it all in his front living room. And it come to somewhere around $29,000 something. Okay. Well, the judge asked Mr. Glacier, is this your credit card? And he said, well, yes. And he says, did you give your wife this credit card? He said, well, yes. He said, so she had your permission to use this credit card? And he said, well, yes. He said, did you give your wife this credit card? Well, yes. Yeah. And so he asked him, then she had your permission to use that credit card? And he said, yep. He said, well, here's the bill. And it's some $29,000 something, okay? And so Mr. Glacier asked the judge and said, okay, Judge, now if I ask you for a gallon of something or a foot or a pound of something, you're going to say a gallon or a foot or a pound of what? If I ask you for an inch or a yard of something, you're going to say an inch or a yard of what? Now you come and tell me you want dollars, and so I'm asking you dollars of what, since dollars is a unit of measurement. And the judge flinched back real quick and he says, hey, you don't have to pay this judgment. You don't pay this judgment. We'll just get a writ. We'll go get your car. We'll go to your work and take your paycheck. We'll get your house. Now, you get real here. You're going to pay this judgment when we're in. I says, I'll tell you what, we're having a flash and blue light special today. You can make it frankincense and myrrh. Wait. Better yet, make it coffee beans, okay? Now, at the saying of that, the attorney for Montgomery Wards came to a half rise going, Your Honor, you can't be serious. And all of us, there was 40 of us plus in the court that day in the back of the court, we proceeded to go into our best because we had immediately realized that this judge had done a landmark Michigan court decision. And this happened in Rochester 52nd 3rd District Court. The judge leaned back in his chair, flipped his pencil in the air, which is what he does right before he cites somebody with contempt, and he said, expletive here, shit, which got put right on the record, right in the transcript. And he says, I screwed up bad, And we were sitting there, we called all the news media, we called everybody, the Wall Street Journal, everybody, with great courage today in the landmark Michigan court decision, the Honorable Judge James P. Sheehy determined that the lawful money of account of the United States government was coffee beans, and we could interpret that any way we wanted. And so what we did is we made 100 bean bags and certified them as $100. And we put 68 1/100ths of a bean in a white line on it and cut the tip of it off. And we paid Monkey Wards, and they didn't say a thing. They didn't say nothing. They didn't want that getting out. Well, then it started going all over the county of Oakland that people were paying their traffic tickets with beans. And this guy had gone out and got one of them Royal Crown whiskey bottle bags, the little purple velvet bag that comes around Royal Crown whiskey. And he'd gone down to a little Chinese seamstress and had her sew on there Jean's beans. And every time you went to court for a traffic ticket, he'd pull out that little bag and tell Judge Sheehy, how many beans is it going to be today, Your Honor? And he'd go, oh, shut up. Get out of here. Get out of here. And so this got all over the place, and one old lady went into the Oakland County Records and Deeds office, and she said, do you have a young man who can help me? I have 2 50-pound bags of coffee beans, and I want to pay my property taxes, but I can't carry that in here. I need a young man to help me with those 2 50-pound bags, and the clerk went, oh, lady, you ain't doing that here. They may do that down at court, but you ain't doing that here. Anyway, this got to be a laughingstock in the state of Michigan. Well, I didn't know it at the time, but the judge actually golfed with my dentist. And they played for money, so they played for skins. And normally Doc beat the hell out of Judge Sheehy, but this day Judge Sheehy was doing real good, and he was up on Doc by $300. And boy, he was rubbing Doc raw, really raw. And of course, I had told Doc this story, and Doc got halfway down to the 17th green, and he said, after Judge Sheehy had ribbed him about the $300 he was behind, he says, that's all right. I just paid the damn thing in coffee beans. And Judge Sheehy took his 9-iron out and flung it down the course. I'm never going to live that down. I'm never going to live that down. Now, Wall Street came with a whole camera crew. And so about 2 weeks later, I had to be in court. And I was in the bathroom, and Judge Sheehy came in with all his bodyguards and 2 of his prosecutors. And I'm sitting on the wall here arguing the law at constitutional Supreme Court level on Article 1, Section 10. Nothing but gold and silver coin shall be made a tender payment of debt. Did I think this was going to fly, and how could I be so stupid as to pull this? And you set me up. I'll never forgive you. And all. I said, what are you talking about, Judge? He says, the Wall Street Journal came with a whole camera crew on the whole story on the landmark Michigan court decision about the coffee beans. Now, you're the only one smart enough to pull this stunt like this. I'm never forgiving you. And so the prosecutor turned to the judge, who is that guy, Your Honor? He says, never mind, just don't bring him in my court with anything serious or I'll have your head on a stick. But every time I come to that judge's court, he would stop the court. We're not here for anything serious today? No, Your Honor, we're just casually observing for the day. Oh, no, you're going to tell me why we're here today. And I said, well, my driver is new on the route. We happened to be in the neighborhood. He wanted to see a really good judge in action. I told him you were one of the best that ever was, and so we stopped by, and we're just here to say hi and check out court today. He goes, that fish smells damn loosely wrapped from here. He then proceeded to suspend court. He went down the hall and set up his court at the clerk's desk, and we were waiting. It's got to be almost a half hour. And we're the judge. This is they don't never break for more than 15 minutes. What the heck? And I looked out the door, and there he was down the hall. The bailiff was coming in and grabbing the cases and hauling them down to the clerk's bench, and he was hearing them down there because he didn't want me to hear any of them because he knew I'd come and help somebody do an amicus curiae. So he took his cases down to the clerk's bench, and as soon as I put my head out the door and I looked down there and I saw what was going on, I could hear Judge Sheehy yelling, "Uh-oh, busted." So me and Judge Sheehy had quite a working relationship for quite a few years on that coffee bean case, but that is a bona fide case, and you can actually use it. The case is called Montgomery Wards versus Eugene Glacier, and it happened in October of 1984. Call up the 52nd 3rd District Court in Rochester, Michigan, 52nd 3rd District Court, and ask them about the coffee bean case, the Montgomery Ward versus Gene Glacier coffee bean case, and they'll probably hang up on you. We don't have any case like that here anymore. Well, you had it at one time, didn't you? I want a copy of it. Well, that record is not for publication. These guys, they think they're going to hide from us. They're not going to hide
that's
from
what
us.
they do.
We're going to chase you down. I'll drive over there, and we will get a copy of that record if I got to ask the judge for a writ. This is how we have to be, people. We have to get
about asserting,
seriously involved, and you have to physically be that person in the belligerent claimant. I'm claiming my constitutional. I want my rights. That's the best I can tell you as a friend. You have to be that belligerent claimant. And when they understand that you're serious as a heart attack, all of a sudden everything changes. And then when you come in the court, "Oh, hi, Mr. So-and-so. Good to see you again. Anything we can do for you today?" I had one student that had trained with me for 10 years, and toward the end he would go into court at the 42nd District Court before Paul A. Cassidy, who was another really good judge. And the prosecutor used to always go, "Murdoch don't have no attorney, Your Honor." And the judge would come back, "Murdoch don't need no attorney. Murdoch's better than any 10 attorneys you know." And they would always let him stand as his own attorney, and he'd always win. I'm telling you, folks, this guy never graduated from high school. But I'm telling you, he was arguing law before the World Court within 10 years, and his arguments were absolutely phenomenal, all the way to the United States Supreme Court. The guy was phenomenal. He was one of my best students. I was really sad to hear that he died of a heart attack recently. He was my very best. He was really something to see and to hear and to read. Is there any other questions we have out there?
Oh, yeah, we have a whole bunch.
Okay, fire away.
Okay, let's go on.
Try and go as fast as I can because I know you got to be close to running out of time.
Nah, we got plenty of time.
Okay.
Yes, 99. Go ahead. Did you have a question for our constitutional man? Go ahead, guess 99.
Probably took too long.
Hello? Guess 99. You just muted yourself out. Guess 99. Go ahead. Did you have a question? Guess 99. Did you want to ask a question? Otherwise, we're going to move on. I'm sorry. There's so many people in line. All right. Just put your hand up again.
Hi, Angela.
Yes. Who's that?
This is Tim.
Okay, Tim, you have to wait. We have a whole bunch of people in line. So, we've got 9 people, 8 people. So, hold on. Put up your hand by pressing *8. And we're going to move on to Angel. Let me see if I can get this thing to unmute. Go ahead, Angel.
Hi. Thank you.
Hi.
Hi. I am in the 11th district, and I was wondering if some case law help stand on when you have attorneys turning in fraudulent paperwork. I have a situation, and I'm battling with that, trying to make sure that they do not bring that fraudulent paperwork into district court.
Do you know it's fraudulent?
Yeah.
Do you know for sure it's fraudulent?
Really,
See, you're making a claim of fraud. Guess what? The burden is on you. That's Title V, Section 556B as in David. The proponent of a rule or order has the entire burden and proof of all claims. So if you're going to allege fraud, my first question back to you would be, have you filed a complaint for fraud?
I filed an initial complaint, and I did use that terminology instead of deceptive. So let me just rephrase that. The paperwork is not the original wet ink signature paperwork. And
okay. All right.
And
it's not the blue wet ink signature. Okay.
And it also has additional information on it. It's lopsided on the paper. It's just so many things that you can point out on it that it is not the original documentation.
Okay, well, guess what? The law says very clearly that if that is the case, they don't have a right to exercise the contract or the benefits of the contract, and that's Uniform Commercial Code 3-203, okay? Uniform Code 3-203, and it very clearly says they have to have the actual note with the original wet ink signature on it to be able to exercise the contract, okay?
Okay.
That's what the law says. If you look it up in UCC, you'll see I'm right. Also, they have to have standing, and the only way they can have standing is to possess the actual note, and that is in Uniform Commercial Code 3-202 parens 2. That if they're not the actual real holder in due course, they don't have any rights or standing to come before the court. Now, under Title 28, United States Code, Rule 17 parens A, it is their burden to prove their standing, and failing that, they don't have a claim for which relief can be granted. So now we go into summary judgment, 12B6 and 56G of Title 28. 12B6 and Rule 56G, in other words, fraudulent pleadings. Now, if you can demonstrate clearly that they don't have this, and that until they present this, and that's what that case before the Massachusetts Supreme Court was about. That is the case of U.S. Bank and Wachovia Bank versus Ibanez, I-B-A-N-E-Z. And it just came down a week ago Friday. And what I can do is probably call in another time because they haven't even given it a site yet, you understand?
Okay.
Maybe tell you where you can look it up. But if you look up on your Internet, go to Google or Yahoo and call up the case of U.S. Bank and Wachovia Bank versus I-B-A-N-E-Z. It'll pull the whole case up for you.
Okay, thank you. And if you have time, if you could address doctrine of laches or defense for that, if you had time.
Doctrine of what now, please?
Laches.
I can barely hear you.
Is it the doctrine of laches?
Mike, laches.
Oh, laches? Laches?
Yeah.
Laches is a species of action where a party of reasonable intelligence and integrity, having a right to take an action as prescribed by law, and having failed to timely proceed and take care of their situation or issue, they give up the right to do so. That's what laches incurs me. And there's another laches, it's called estoppel by laches, which means that if they did do that, they are estoppel from proceeding against you.
Okay, well,
go to Black's Law Dictionary and look all of those up. Estoppel by laches, L-A-C-H-E-S, laches, the actual definition, and laches incurs, I-N-C-U-R-R-S. And you'll see that is exactly what they say.
Thank you.
Okay, God bless you, and I wish you luck on that foreclosure.
Thank you.
The biggest thing I can tell you about that foreclosure is be persistent, never give up, never give up, never give up. Quitters never win, winners never quit. You're always been a winner, and you're going to be a winner today, and we ain't letting this go. I actually had a case go before a court 2 weeks ago, and the judge ruled against my guy, and my guy turned and told him, he says, I'm not a quitter. I never quit. He proceeded to pull a claim of appeal to the Michigan Supreme Court out of his bag and handed it to the opposing counsel and the judge, and they were shocked that he would be that gutsy after all this time. But I'm telling you, that's the attitude you have to have if you want to win.
Thank you so much.
Okay? God love you.
Thank you. And, see here.
You allow me to chat, Angela?
Yes, I'll do that for you. Hold on 1 second. Let me unmute her chat. We're going to move on. Go ahead, West Michigan. Did you have a question?
Yeah, I do have a question. I'd like to go into this 600 1.3204 in a little bit more detail. You're basically saying that if there's a pending lawsuit, they can't foreclose?
They cannot foreclose by advertisement. It's forbidden.
Okay.
There's actually 4 sections to that, and you have to meet all 4 sections, and there's an A, B, C, and D, and the B is the one that if you have anything legally pending on the case, if there is a legal matter pending on the case, they cannot do a foreclosure by advertisement, foreclosure by advertisement. It's forbidden. Also, you should know in Michigan that it's been ruled by attorneys and courts that advertisement, foreclosure by advertisement is actually in direct conflict with TARP law. And if you want, if you give me an address or an email, I can probably send you a packet that would show you how these sheriffs totally violate that statute.
Okay,
give me an email.
I'll take care of that for you, Westminster.
All right, you take care of that, and you know the email I'm talking about, the one with the sheriff's star on it. That's Exhibit 10 that I gave you. Okay.
Yes, I know who you're talking to, so I have their email, and I'll just forward the information. You forward it to me.
Okay.
Okay. Now, when you say they can't do the foreclosure by advertisement, if they start it and litigation starts, then by law they're supposed to stop it. They're not supposed to go ahead with the sale and the sheriff's deed.
That's right.
So if they go ahead with the sale and the sheriff's deed, that would be grounds to set all that aside.
Right. That would be to set it aside, right?
Okay. All right. Now,
that would be a fraudulent transaction. So guess what? Now we're into the clean hands doctrine. Look up, go to Black's Law Dictionary, look up the clean hands doctrine. You want the case of Franklin versus Franklin. That's 283 Southwest 2nd, 486. That's 283 Southwest 2nd, 486. One seeking equitable relief cannot come to court, seek an equitable relief with unclean hands.
Right. Because
they make the court a party to fraud. And if you make the court a party to fraud, the judgment is void ab initio from its inception.
Right.
Okay?
Right. Okay.
That's the way I would follow that up.
In this particular case, I didn't get any lawsuit filed prior to the sheriff's deed, so there is a sheriff's deed that's already in place.
Was it signed by the sheriff? Was it signed by the sheriff?
Signed by a deputy sheriff.
No, I'm sorry. It has to be signed by the sheriff.
By the sheriff? Okay, now where do I find that?
Look that up around MCLA 57.10 and around in those areas. He has to be if he was a deputy, he'd have to be a special deputy. Then he'd have to be sworn in as a special deputy. Then he'd have to have an oath of office as a special deputy. His office would actually have to be recorded as a special deputy. Then he would have had to have been sworn in by a lawful sheriff who had his oath of office. Now, if you go check the sheriff's oath of office, within 10 days of the election date, and most of these election dates are on November the 2nd, the 5th, the 7th, or the 10th, okay? So let's say the latest possible date of 10 days from November the 10th would be November the 20th. Now you go pull his oath of office. All of a sudden, you're looking, and he signed his oath of office on February the 6th. Whoa! He's 2 months late. Got me? Now, you call the Office of the Great Seal in Lansing, okay? Call the Office of the Great Seal. I think the gal's name is Helen or Marie. And ask her, it's about a $3 bill, for a copy of the judge's certified oath of office. She'll give you the one with the gold seal, the apostille seal right on it, and send it to you that a check of the records on such and such date was found, and that the sheriff's oath of office was taken at this time and deposited in the Office of the Great Seal. And you're going to find out. That has to be done within 10 days of his election, okay?
That's right.
So if it isn't done by the 20th of November, it's probably a real good chance he don't have an oath of office timely filed. Now, if he doesn't have an oath of office timely filed, we go to MCLA 201.3, which says, if he neglects or fails to file his oath of office within the time and in the manner as prescribed by law, that's within the 10 days, and with the Office of the Great Seal and the county clerk's office, then he voluntarily vacates his office. So he's quorum non judice. He's not a real sheriff. He's not a person. You're not in the presence of a person, a lawfully seated sheriff. So how can you swear somebody in?
Give me the MCL number again. 201.
MCLA 201.3, parens 7.
Parens what?
Parens 7. The seventh note.
Okay. Yeah. Okay.
And you're going to
All right,
see
yeah,
that that's the God's honest truth. And guess what? If he's not he's not a lawful sheriff, then any judgment, anything he did is void of ab initio. That's Puerto bail bonds for the state of Texas, okay?
Right. Yeah, I had a district judge one time that didn't have an oath of office on file, and when I brought that to his attention, he did not want me in his courtroom.
No, he wanted you out of there. Just get the hell out of here. Yeah,
right.
Go away. Don't bother me.
Right, exactly. Okay, I can get a hold of you via Truth, I take it?
And you get a hold of me, and I'll get right back to you, and anything you need, we'll try and figure a way to help.
Okay, that sounds good. Thank you. I appreciate your help.
All right, God love you.
Thank
Good
you.
luck. Good luck on pushing.
Thank you. I'm a good pusher.
Good. Push. That's the name of the game. Push.
All right, we're going to move on. We're going to push forward to guest 91. Go ahead. Did you have a question for our special guest speaker?
Hi.
Hi.
How are you? Hi, how are you this evening?
I'm hanging in there best I can. Hello. Are you there?
Wonderful. This show has been very edifying. I have about 3 questions that I'd like to ask.
Okay, go ahead.
One of the questions is my wife has a tuition statement, Form 1098T, and we wanted to know if it's possible for her to be able to get anything from it, or how should we deal with the form? And
okay. All right, this is my most sincere counsel, okay? The wives actually have a chance out of this by claiming that they're an innocent spouse. Do you understand? Do you ever hear the term innocent spouse?
No, sir.
Well, you're going to have to get with Truth, and I will give her the documents that go with innocent spouse, and it tells basically that in the Bible she comes under your house and that you're the leader of her house and that you handle all the tax matters, okay, and that she just follows in line with whatever you tell her, okay, that all tax matters are to be taken care of by you, and that she claims the status called innocent spouse, okay. Now, I've won every case except one, and there's been over 100 now on these innocent spouse things. They just know that a lot of times the husband tells her, this is what I want you to do, this is what I want, and she's of a religion that says that she has to submit to her husband and live under his rule of his home. And we have all of the Bible quotings of this, and she's going to rely on those Bible quotings as making her an innocent spouse, and we submit that file to them, and almost always the IRS just leaves the wife alone there.
Okay.
That's how we handle it. The other way you're going to handle it is you're going to put that 1099 in with your tax returns, and you're going to take care of whatever your liabilities and obligations are and use that. And if you've been paying on that debt, then you have a right to make claim for some of the deductions for paying on that debt.
Okay.
But I have a statement that I'm going to give you right now, and that's I pay all lawful taxes when they become due. If you honestly owe them, then I'm recommending you honestly pay them. If you don't honestly owe them, then we can sit and talk about how that came about.
Okay.
But I don't do anything unlawful, illegal, immoral, or unethical. So I'm not going to tell you to do stuff that's illegal, immoral, or unethical. I'm going to tell you exactly what the law says and then allow you your ability to make your determination, and you're the one that's going to voluntarily make your determination as to whether or not you have a duty or a responsibility under the law, okay? That's how I win. That's how I win, by the way.
Okay, and what I
that
wanted
way they
to
can never catch you doing anything illegal.
Okay. What I also wanted to say is we're not married in the traditional sense. We're married common law. And what we did was we made vows towards one another, and what I was planning on doing was
Let me ask
taking
you
those
a question.
vows.
Is there any place in the law that says you have to have the state recognize your marriage?
No, sir.
Bingo. Is that a right? So you had a right to get married before the state even was a state, huh?
Yes, sir.
What does the preamble of the Constitution say? That the rights come from God. The state doesn't even enter into it, right?
Yes,
and
sir.
that to preserve these rights undiminished, it says, that to preserve these rights undiminished to us and our posterity, we ordain this Constitution. So the Constitution is supposed to protect the rights. So you had the rights previously guaranteed before the Constitution even was drafted. You had them, right?
Yes, sir.
Article 1, Section 23 of the State Constitution 1963 says the enumeration or addition of this Constitution shall not be construed to deny or disparage other rights retained by the people. So you had the rights before. Can they pass a law taking away your rights that you had before? No. The Ninth Amendment of the U.S. Constitution says the enumeration or addition of this Constitution shall not be construed to deny or disparage other rights retained by the people. You had the rights when your forefathers landed on this soil before the United States of America even came into being. You had the rights previously, right? How do you add on to the Constitution and take away my constitutional rights? You can't do that. That's unmotivated.
Yes, sir.
So you had the right before. So we're not even going to argue whether or not the state can intervene between your right to get married or your right to work and be an attorney. If you want to be an attorney, I don't want to get the license and pay the fee. Well, you're not required to. Rhode Island, Pennsylvania clearly says that. It's 319 U.S. 105. It says no state may convert your constitutional rights into a privilege and then and there require you to go pay a fee and get a license for the exercise of the right. And if they do, you can ignore the license and the fee and engage in the right with impunity. That's Shuttlesworth versus Birmingham, Alabama, 273 U.S. 262. So now, did you rely on the counsel of 9 justices of the Supreme Court? Uh-huh. You got a perfect defense of the element of willfulness then, right? Prosecutors got to prove you willfully and knowingly avoided or known to your task under law with a moral certainty, right? He can't perform. Does he have a real case against you? No. Go fish. Leave me alone. Just go away. Don't bother me.
I have 2 more questions.
Okay, go for it.
And I think the second question is, I've been sending in some A4Vs, presentments. I think that I've been doing it quite correctly according to the example.
You have to do it perfectly. You have to do it perfectly accepted for value. And you got to stick to your guns once you go, too.
None of them have been settled. And what I was
all right, let me ask you this. Is it your fault or their fault? Is it your fault or their fault they're not settled? Who didn't answer last?
Well, what happened? Well,
did they answer you back?
No, sir.
Well, then you defaulted for failure to answer and respond. That's Michigan Court Rule 2.111 parens E. Failure to answer otherwise plead is an omission of facts and evidence. So I guess your A for V is accepted then, huh? Didn't have them write you back and tell you it was not accepted, did you? So you can only assume that it was accepted in your favor, right?
Yes, sir.
Does that make sense to you? Does that make sense to you?
Yes, sir.
Perfect sense to me. Failure to answer otherwise plead is an omission of facts and evidence. So you must admit that I settled.
Yes, sir.
Okay.
And the second question is, I was listening to a program that Truth was on, and she made a statement about the DOT 150 as far as driving privileges. And I'm in a situation right now to where I can't afford to buy any insurance, and I certainly can't afford to have my car re-registered. And I've been studying the law in regards to driving issues, and I understand that driving and traveling are 2 different things.
That's correct.
And
driving is a commercial venture for profit or hire on the open road. Traveling is your right under the Constitution, as so stated at Shapiro versus Thompson, 394 U.S. 618. It says the right to travel is such a basic right it don't even need to be mentioned. That it's self-evident in a free society. The right to travel length, width, and breadth is self-evident, and what makes us being described as a free society. Therefore, the right is established. So, I tell the police officer when he pulls me over, I know you're going to find this hard to believe, but I just ask you to take a moment here and listen up. I says, I'm not driving. Driving is a commercial venture for profit or hire on the open road. I don't do that. Some people actually put a sign in their back window, not for hire, okay? So that there's no question that they're not for hire, okay? So if you're not for hire, then you can't be on the open road operating in commerce, can you? So you have to be exercising your right to travel, right? And I've heard all kind of arguments from people on how they do it. Some people make up their own license plate, my car, and they put on it, I've heard other guys take the site out of Shapiro versus Thompson, 394 U.S. 618. They put it on a white plate with black letters so it looks like it's a government plate. Most people assume they're some kind of ambassador, and they just leave them alone, especially if they put it on a Rolls Royce, okay? I had a guy do that for 4 years, got away with it totally. But I'm telling you, the reality is, if you're pulled over, you have to have your plan and your organization all set up. You have to have your facts and your ducks in a row. Now, it's impossible for me to even get a ticket, and I pled with you. Come on, give me the ticket. I'll make you famous. We'll go to Washington. I'll even pay for your hotel room. We'll go look at the wall together. And I actually heard him talking to his sergeant on the radio, and I heard the sergeant come back, for God's sake, don't give that guy no ticket. For God's sake, he'll end up owning the whole town. And I had given him the 27-minute seminar on the right to travel. You see, I'm exercising my right to travel, Shapiro versus Thompson, 394 U.S. 618, and that right can't be converted into a privilege. Now, the state of Michigan arbitrarily and erroneously converts my right to travel into a privilege, and then in there requires me to go get a license and pay a fee for the exercise of the right. That's in violation of Murdoch versus Pennsylvania, 319 U.S. 105, which says no state may convert my constitutional rights into a privilege, and then in there require me to go get a license and a fee. And if they do, Shuttlesworth versus Birmingham, Alabama, 373 U.S. 262 says I can ignore the license and the fee and engage in the right with impunity. That means you can't punish me. Now, since I relied on the counsel of 9 justices of the U.S. Supreme Court, I got a perfect defense of the element of willfulness. That's U.S. versus Bishop, 412 U.S. 346. Willfulness is defined as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. So you see, your prosecutor does not have a claim for which relief may be granted. So this complaint is fraudulent and spurious at best. Now, I will move to dismiss this thing for fraud, and I will exercise my right for a summary judgment pursuant to Michigan Court Rule 2.603 and 2.116, Friends C, Friends A, and I will ask to collect my costs and fees for having to defend this patently fraudulent and spurious complaint. And that prosecutor is going to get shot to pieces by that judge for allowing this case to even come to trial. He should have settled this one out in the hall where it wouldn't be so embarrassed. The prosecutor is going to get shot to pieces by that judge. Well, believe it or not, I've had judges actually take the prosecutor to task for even trying. So wow. I've actually had the judge turn to the prosecutor and say, well, Mr. Prosecutor, would we venture a response? And, of course, they had put a whole bunch of lawyers in the back of the court to watch me get hung, you know. And all the lawyers chipped up and said, yeah, on your feet, Prost. We want to hear this response, you know. And the judge said, shut up or I'll clear this whole courtroom. And he couldn't respond. They had to dismiss everything, and the judge basically read him the right act. Never before had a young man, not an attorney, so literally overwhelmed under counsel of the prosecution and licensed attorney. So I can tell you, when you give these kind of arguments, a lot of times the cop's going to say, okay, you wait right here. Don't do nothing. I'll be right back. And he'll go back and call in on his radio, and he'll tell them who they got. And when they find out who they got, it's going to be, oh, for God's sake, don't give that guy no ticket. He'll end up owning the whole town. And the guy comes back and says, I'm sorry. I'm going to let you go with a warning here, but do me a favor. Just wait 5 minutes here so I don't got to watch you do it again, okay? And just, I said, oh, sure, out of courtesy, I'll be happy to do that for you so you aren't frustrated because you've been a very professional officer, and I actually appreciate a courteous professional officer. And so I'll honor that for you. And so I sat there in the gas station, and the guy who owned the gas station asked me what I was doing there. And I said, well, an old guy just had a stroke, and he just got out of the hospital, and I'm here to get gas for his truck and get him some food because his icebox is totally bare. And he says, well, buddy, your money ain't no good here. He says, whatever you want, you just put it on the tab. It's on me. Anybody who's got guts like you, he says, it's on me. Wow. So the whole gas station came out to watch me get skewered. I never get this one old lady. Inez, get out of the car, honey. This one's going to be good. He ain't got no plates and no license. Come on, girl, get out of the car. And these old folks stood around and watched me hammer this officer. And to this day, every time I see that officer, he just smiles, goes the other way. But this can be done, folks. It can actually be a little bit of fun. But I tell you, as one of my best rules is courtesy. Courtesy pays. I cannot tell you, I win more cases on just plain courtesy than I do any other thing. Rather than fancy footwork and legal maneuvering, courtesy is very, very important. And usually when you treat people with reasonable courtesy, they come back and treat you the same. That's happened a lot. Of course, if you're going to give them a ration of stuff, they're going to come back and give you a ration of stuff.
All right. So, we've got West Michigan.
Okay.
Go ahead. Did you have a question? West Michigan. Go ahead.
Nice talking to the last fellow.
Okay, I'd like to go into this traffic and travel issue in a lot more detail with you, specifically any. All right.
Well, if you get a hold of our good friend Truth here, and I will have a whole brief for it. I'll have a whole serious brief on it with the exhibits and everything. All the definitions and everything you can see. We've got a guy who actually has a TV program in Ann Arbor, Michigan, on public television, and he actually put the whole trial on his program.
Wow.
And, of course, they pulled his program off the air after that case. So He was showing everybody how to get out of having a traffic ticket.
Okay, definitely. I'd like to have that information.
So I will be happy to cooperate any way I can to make sure we get this vital information out to every one of you out there that needs it, so you can be that one in persona making your claim. Because I've been doing this stuff for 42 years now, and I got quite a file.
I bet you do. That sounds great. All right, thank you. I appreciate that.
Thank you for your question. I appreciate your time, too.
Okay, we're going to move on to Potatum. That's cute. Go ahead, Potatum.
Hi. I believe I heard you speaking at you about 17 years ago in Washington, Pennsylvania, at a rally.
Okay, well, don't say nothing.
No, I'm not. I'm not going to give it up. I have bought
special problems.
Yeah, I bought tapes, and I have learned a lot from you, and I thank you for that. I have. The problem is the judges I've gone before, they lie, they're corrupt. Now,
I agree.
How does one go about, what do you call it, arresting their bond, or?
Yes, we go after their bond. We go actually and make a claim against their bond. We file an affidavit of complaint. We file an affidavit of fraud. They cannot hold their bond except in good behavior. If you look up Article 3, Clause 1 of the Constitution, it says, judges of the Supreme Court and Inferior Court hold their office during good behavior and shall receive for their services a valuable compensation, which shall not be diminished during their continuance in office. And interestingly enough, I got a Supreme Court Chief Justice off the hook when the IRS was going to run her out of office. And I went and met with her because we had a mutual friend, and I told her, Your Honor, you're immune from the IRS. And she said, and how do you figure that? And I told her exactly, you're a Supreme Court Justice. Judges of the Supreme Court and Inferior Court hold their office during good behavior and shall receive for their services a valuable compensation, which shall not be diminished during their continuance in office. And since, you're in good behavior and you're still in your office, since no diminishment was stipulated as lawful, all diminishment is forbidden to include IRS taxes. So you're constitutionally immune, Judge, and if you want to check that out, look up the case of Evans v. Gore. Judge Evans sued I.R. Gore of the Internal Revenue for diminishing his salary during his continuance in office, and he won all the way to the Supreme Court. So you check that out, Your Honor, and you're going to find out they can't do nothing to you. Now that judge has ended up being the chief judge of the Michigan Supreme Court. And the other day when I was in front of the Michigan Supreme Court, she kind of gave me a wink. So she told me that I was kind of a handy fellow to know. You never know when you do a kindness for somebody how it's going to come back to bless you. So I recommend you do as many kindnesses as you can. I followed that same procedure on another judge. I didn't know he was a judge at the time. He thought I was the librarian at the Detroit College of Law. And I thought he was just a crazy professor. He wore Hawaiian bag lady shirts and he dressed like a bag lady. And every Sunday he'd come down and break the copy machine at least 3 times. Of course, I'd fix it. I was a copy repairman. And he'd lose his law books, and of course he'd stack his law books 3 feet high on a big 8-foot square table, and I'd help him find them. And this went on for about 3 years, and then one day I got nailed and hauled before him for income tax stuff. And I says, you look very familiar to me. He said, well, most people have confused me with the Honorable Paul V. Godola, Chief Judge of the United States Federal Court. And I went, oh, well, Your Honor, I don't want to have an ex parte hearing. I wouldn't make you look bad like that. And he just smiled and laughed and then turned to the prosecutor and he told the prosecutor, you damn well better be able to prove this case or I'm going to have your head on a stick. So you never know when you do kindnesses for people how it can come back and bless you. And that judge ordered me released in my own cognizance and I blew their doors off.
Is it possible to get from you a more step-by-step procedure on arresting a bond?
Yes. I will be happy, and I will get that to Truth, and she can get it to you guys, and we'll work it out. And I would ask that you help her out for her organization and for this generous lady who runs this talk program, that we make sure we keep them in business and make a small donation. Well, you can make a big donation, either one, but they need, obviously, some help to keep this thing going because it takes that kind of resource programming. And if every one of us out here in TV land was to do that, it would keep them on indefinitely. So these are the kind of things that you can do to step up to the plate and make sure these people keep going. Because a lot of times they're going on a wing and a prayer and vapor in the gas tank, you know what I'm saying? So we need to generously donate to these people and make sure that they keep their operations going so you can get this kind of valuable data.
I appreciate it. Angela, is this Angela on here?
Yes.
Could you give out that contact information?
Which
is this
contact
for truth?
information?
Yes.
Is this for truth? All right.
Yeah, it's her email. Do you want Truth? Truth is on. Would you like us to give out your email address, or how do you want to do this?
I prefer they go to the myprivateaudio.com so we can move on.
Okay, just go to the website, myprivateaudio.com.
Okay, thank you.
Okay, and click on where it says guest speakers, and then scroll down to where it says truth, and then click on that. And
we'll be happy to get you anything we can to help you keep going.
Thank you very much.
Okay,
and I appreciate you. I appreciate you still hanging in there after 17 years.
Yeah, it's been tough, but I learned a whole lot from you, and I appreciate you.
Not to worry. I really appreciate your following too. I wish more guys were like you that would hang tough and just keep going.
Thank you.
God bless.
Heidi.
Where are we at?
We've got we like 15 people but in line, so
okay.
Yeah. Okay, Kokomo Joe, you're next. Go ahead. Did you have a question?
Hey, hi. How are you doing?
I'm hanging in there best I can.
Good. All right. The big issue for me is property tax. Can you do that all on property tax?
Yep.
You started talking about a few things. Can you elaborate a little more?
Okay. Title 31 United States Code. Look up Title 31 United States Code, Section 742. Now, I already know you're not going to find it because they took it out of all the law books. You will not find that book in the law books in the entire libraries of the entire United States, okay? Because they moved it to Section 3124 in the back of the book. Of course, they didn't put in there that it was repealed, revised, or otherwise changed and moved to Section 3124 because their intent was to hide it. They call that fraud by silence. Look up the definition of fraud in Black's Law Dictionary. You'll see a section that says fraud by silence. And that's what they did. Now, here's the deal. Title 31, Section 742. And, of course, if you get with Truth, I can give you that data, too, because I've given that to her before. And there's a whole file on it that's hundreds of pages long that explains all this in great depth. It also gives you the case of Memphis Bank versus State of Tennessee at Al Garner, which actually has Title 31, Section 742 right in the case in the first couple of pages. So you know there was such a thing as Title 31, 742. Now what this does, in brief, simple explanation, it says, except as otherwise provided by law, all stocks, bonds, treasury notes, and any other obligations of the United States are exempt from state, municipal, and local taxation. This exemption extends to every form of tax which would require that either the obligations and bring things in your pocket or the interest thereon or both be considered directly or indirectly in the computation of the tax. Now let's talk about how they figure property tax. They grab three comparables that are similar to your house in basic. You have one of these, they have one of these, and they take three comparables and then they add them up. Let's say we're talking about three houses roughly in the $100,000 bracket, okay? So they add up three houses in the $100,000 bracket, so that's $300,000. They divide that in half, so the average that they're working with is $150,000, okay? Then that's the 50% amortization value, okay? Then they take that and they multiply it by how many points that your electorate in your area have voted for. Let's say it's around 13 to 15%. And that's your school taxes, your property, all your taxes included, okay? Then they take that percentage and multiply it times that $150,000, and that's how they come up with your property tax, okay? The ad valorem property tax, that's how they do it. Okay, now did they use obligations of the United States government to figure that? Yeah, they use dollars, okay? And what are dollars? Those green things in your pocket, Federal Reserve notes. Except those aren't real dollars because real dollars are defined as gold or silver coin in a certain percentage and quantity, okay? So they're using obligations of the United States government to figure this stuff, and they're using interest on that obligation to figure this stuff. So now we come up with this argument, okay, we look up Title 12, Section 411, and it says the said obligations, the said notes are obligations of the United States. So it's clear they've been defined as obligations. So they're violating the Title 31, 742 or the Title 31, 3,124, by taking obligations and figuring them and the percentage thereon to figure the property tax. So they are forbidden from doing that, so it's not lawfully done. So you contest the tax, but they don't have the proper authority to do that tax because they broke all that federal law, and the federal law is supposed to be the primary law. And you're going to object to the tax. I'm telling you, the state will not contest that argument because they know we'll get beat.
Well, my city doesn't put a dollar sign on anything on the tax bill.
I don't even want to hear that. It's custom and usage. Custom and usage. Okay, show me how they figured the property tax then. What value system did they do?
I believe
Are we going to get back into that coffee beans argument again? I have a feeling. Toothpicks? Are we in the toothpick argument? What are we talking about? Explain yourself, because a dollar is a value of something. It's a quantity of something, like a gallon of milk or a gallon of gas. Dollar is the unit of measurement. What is the actual commodity you're measuring?
Right, and you get a letter.
Sure, show me. I'm asking. This, if I have to, I'll get a motion to compel discovery.
Well,
Brady versus Maryland. We'll do the Brady versus Maryland and the U.S. versus Jenks under 18 U.S. Code 3500. You're going to have to comply. If you don't give me my discovery, you're denying me due process. Title 5, Section 706 says if you deny me due process, we get to start this whole thing over again. You want to go there? Fine. You see, they don't want to play. They don't want to go there. They can't go there. You understand? They're not going to push that argument. They're going to walk away and say, well, I'll go after the other 99 million suckers. We'll let this one go. He's too smart. Also, you waitresses out there, I'm going to tell you right now, you need to be asking every person that leaves you a tip, is this a gift? Got me? Because if it's a gift, it falls under 102A. I tell every waitress, I says, now, I'm telling you this is a gift. There's a reason I'm doing that. If I tell you this is a gift, it now becomes a non-taxable event. Now, if you get one over $10,000, you marry him, he's in love. You understand? And you can write him off as your husband. But if you don't get one for $10,000 and you asked if this was a gift, guess what? That's tax exempt. That's Title 26 United States Code 1028, which says tips or gifts and as such non-taxable unless over $10,000 each. So what you got to do is say, hey, is this a gift? And they'll go, yeah, and you go, thank you, and just walk away kindly and know that. And when they come to bug you, I tell them some IRS agent comes in here and gives you a bunch of stuff. First of all, I'll tell them there's a guy in a big brown jacket looking for him. And if he catches them in here harassing the hard-working waitresses, he's going to take you out in the parking lot and tap dance on your tonsils till your bowels move. You understand? Because it happened already in a restaurant. And when we crossed the floor, my buddy says, I knew I smelled something bad in here. And I go, no, fellas, let's stay calm. Two big farm kids that roil these 150-pound bales up into the loft all day. You know what I'm saying? After a while, you get kind of strong.
Stay in the mouthpiece. Talk right into your mouthpiece.
All right, I'm talking in the mouthpiece. Can you hear me? Can you hear me?
Yes,
okay.
Thank you, yes.
Anyway, you waitresses out there, you need to start asking, you know, is this a gift? Is this a gift? Is this a gift? Now, that's the best tip you ever got, the best tip, because tips are non-taxable receipts pursuant to Title 26 United States Code 102A. Now, if you doubt me, go down to the library, pull up the U.S. codes, get the books with the 26 on the back. It's a maroon book. Turn to 102A and read for yourself. Then you're going to understand, hey, he's right. I didn't get no tips. I got gifts. And I asked every time. So when they come ask me about my tips, I didn't get to give tips. I got gifts. I asked. Then they'll go, oh, shoot, we got another smart one. We got to let her go. Now, that's the best tip you ever got.
Okay, Kokomo Joe, is that good for you?
One side question to that. Okay, so do you end up taking, how do you get, that's federal, okay, I believe what you're quoting there is federal, so how do you get that into the case? Do you sue them, or do you take them to federal court, or do you just, put it into your
they're going to write you and tell them you owe them, right? They're going to write you and say, you owe us this amount. Now, you write them and say, hey, wait a minute, under Title 15, United States Code, Section 1592, I'm asking you to verify that debt. Can you do that? You got 30 days. If you don't verify that debt in 30 days, I'm going to assume this matter is resolved in my favor, and have a nice day. If you injure me, I will sue your socks off. But if they keep going, then you demand the hearing. Okay, I'm demanding the due process hearing. That's pursuant to Title V United States Code, Section 706. I have a right to a hearing. I want my hearing before you touch any of my property. If they touch any of your property, you got a $100 million lawsuit. If they don't touch any of your property, they give you the hearing, you go down there and tell them about Title 31 United States Code, Section 742, that they're in clear violation of federal law.
Okay.
That sounds great. Thank you. I'm going to mute.
Well, I'm trying to keep it simple. I really am, because I know this gets to be very strenuous. So I'll keep it simple.
We have a lot of people waiting, so let's
go
to our next question.
Let's shoot. Go for it.
Hey, marathon question and answer session. Okay, East Michigan. Go ahead. East Michigan.
Okay. Yes, can you hear me?
Yep, I hear you fine.
Okay, I have two questions. One is I received an email very recently that stated that there were two constitutions, one for the United States and one of the United States. Is that true?
You're right. You're absolutely right. If you'll notice, the old documents used to say they signed it on the head of the title, These United States of America. Under the new United States Constitution, it's the United States of America, the corporate United States of America, because in 1933 they went bankrupt. If you doubt that, House Joint Resolution 192, June 5th, 1933, go look it up. You'll see I'm right. It's in the history of the 73rd Congress. Except you're going to spend 12 to 15 years finding a history book of the 73rd Congress, because they hid all the books. No. Really? Really. But you can go to the University of Michigan Law Library, and that smart, old, beautiful lady that sits behind there with that silver hair, she says, you know, I had a bad feeling about that when that happened, and those books all disappeared, so I microfished the whole book. And I says, oh, you blessed thing. You wouldn't happen to have a copy of 192, House Joint Resolution 192, June 5th, 1933. She says, I will go look. I said, oh, bless your heart. She came back with one in absolute clear black copy, and it clearly says that the United States of America was bankrupt.
Right.
Now, can a bankrupt corporation exist in law? No. They don't exist. Okay? How do they come down here and turn the lights on? I asked this one judge. How does this court even open their front doors in the morning? They're all bankrupt. I further, this prosecutor here, I got a card from him, Judge, and I'm here to tell you, and I checked the clerk of the bankruptcy court, and he is not a trustee of the bankruptcy court, and the only person that can speak for a bankrupt corporation is a trustee of the bankruptcy court. And I checked his card on it. It isn't even raised letters. He's not even proud of being a prosecutor. I said, but if he was a trustee of the United States Bankruptcy Court, this card would have raised letters on it, and it would say right on it, trustee of the United States Bankruptcy Court of the United States of America. Therefore, he doesn't have a right to say nothing, Judge. And he turned to the court and told that judge, who was Polish, by the way, you have got to be kidding. And the judge told him to shut up and sit down. She'd handle everything. Then she turned to me and proceeded to tell me that I was one of the finest gentlemen she'd ever had to have appear in her court, and that she'd never met anybody who was as courteous as I was, and that she was ordering me released on my own recognizance immediately, because they did not want to talk about bankruptcy.
Okay.
You want a winning argument out there, folks? That's a killer. They shut that court down cold.
Okay, and I have one more.
They don't want to talk about bankruptcy, because a bankrupt corporation is civilly dead. They don't exist in law. They only exist on that trustee's docket. If he ain't a trustee, that prosecutor don't have a right to speak. Walk into court, demand a copy of the guy's card, his business card. Tell him anything you got to, but tell him you want to make sure you mail the papers right to him. And when you get his card, look on it and see if it says trustee of the Bankruptcy Court of the United States, and that's evidence right there. Yeah, he's not a trustee. It would be on the card if he was a trustee. So he can't speak at all. His face was purple, I want to tell you. And he was the top prosecutor for a certain county that we all know well. All of a sudden, he had to shut up and sit down and listen to that judge, because she was not fooling. Said, I'll handle this. You just sit. Don't say nothing. Now, that is a secret weapon, and it works. So If you're getting jammed real bad, and you're going to find as the more you get in here, they like to jam you guys. We need 100 million of you guys out there to do the same thing I did right now. Think we can do it by Friday? That's what I'm asking. Come on now. Get the biggest bunch of fire in your boiler you can, and let's go do it. Everybody go down and tell them, hey, now I am a reasonable man. I will be happy to be reasonable, but what we have here is a failure to communicate. I'm sure we can work it all out if you're willing to play serious ball, and let's go by the Constitution. I'll go home and mind my business. Where do you?
All right. And I have one more quick question.
Okay.
I want to know, is there a difference between accepted for value, the AFV, or the UCC method that I've heard about?
There is.
Okay.
But whenever you do these methods, you have to know the exact procedure. Don't just go half-assed into some of this stuff. There's a lot of our people that go out and file these UCCs, but they don't even do their UCC1. Well, guess what? That judge has a computer on his bench. Did you happen to notice that? I actually had a guy, and he was in there arguing UCC, and the judge flipped around and showed the computer and says, buddy, you don't even have a UCC1 on file. How are you arguing UCC? You see, if you're going to play, know all the rules. And without you putting a UCC1 in, you're doing fraud, you see. So how can you now claim to exercise the UCC? So all I'm asking you is if you're going to cite some of this stuff, please check out all of the programming so you do it right.
So both of those methods are good?
Yes, they work.
Okay.
You know why they work? Willing buyer, willing seller. That's why they work. Okay?
All right.
Whatever two people can agree upon in writing is enforceable in the court of law. That's the statute of frauds. MCLA 556.132. MCLA says whatever is in writing is enforceable in the court of law. I'll give you a for instance. Coach Bo Schembechler sat down with a bunch of big moguls, and he was going to be the big coach and the leader breeder on this big ball team, okay? And he had the presence of mind to go to dinner with these guys, and when he did, he worked out all of the details of the contract on a napkin. Stuffed it in his pocket, went home, okay? Okay, well, there was a falling out, and the leadership wanted to change, and they wanted to dump old Bo. And all of a sudden, Bo was having to go to court because he said they had a contract with him and that they had a balance due and owing on the contract. And luckily, he had that napkin and saved it in his files, and when we got to go to court, he could prove that there was a contract, and it was in writing. It was on a dinner napkin at a restaurant, but it still was in writing, and guess what? His contract got enforced. It wasn't word of mouth anymore. You know what I'm saying? He had a napkin that showed the outline of the contract. So what I'm telling you is when you get into these rules, if you're going to do these rules, make sure you are meticulous in setting up what you're going to do.
Okay.
Make sure you follow those rules exactly. Then you are in a winning posture. But if you just go on he said, we said, they said, maybe, you're just done.
Okay.
So don't go doing stuff halfway. Make sure you've got the rules. And one of the rules, if you're going to use UCC, is you have to have a UCC1 on file.
Okay.
So a lot of people aren't aware of that.
Okay? Yep,
All right,
thank you.
I love you. Take care of yourself.
Thank you.
Thank you.
Thank you. Okay. Jamie, 7777.
Hello.
Hi.
All right. My name is Jamie Good. I'm from Johnson City, Tennessee. I'm a veteran, United States Air Force.
Good boy.
Truth and the Start. Y'all doing a good job. Keep up the good work.
Oh, we're trying.
I don't have a question. Anything that's going on that you talked about tonight. My question is kind of out there. I was a veteran. I was charged in 2000 for felon in possession of a firearm.
Okay.
I was convicted and sentenced to 7 years in prison. I'm currently on probation with the feds. I need to fix that. My charge was 922G, gun violation.
Okay.
And I don't know
was the weapon used in any crime whatsoever?
No, sir.
Okay. Were you on your own property when you had this possession?
Sir?
You see, there's differences in the rule. If you're on your own property, you can have a weapon any way you want. There's no law against it.
Right. The weapon was, I was at an apartment complex, and the weapon was there.
Was in your apartment, right?
Right.
How did they ever get a conviction on that?
No, I was outside the apartment.
Outside the apartment?
Right.
Well, when you go out on the public streets, they reserve the right to try and control, believe it or not, based in commerce, on you being on the open road. But
right.
Let me tell you a secret, and if you get with truth, we can get you a lot of documentation to show that you are totally entitled to your right to keep and bear arms. Keep and bear. The word port arms comes from the Latin word portare, portaro, meaning to carry. Okay? You look up any Latin book will tell you porto, portare is to carry. Okay? The law is very clear. It says the right to keep and carry. Okay? And that right shall not be infringed. Okay? Now the Supreme Court was upheld in a case called Marbury versus Madison, 5 U.S. 137, 1803. The first Chief Justice of the Supreme Court, John Marshall, gave the decision of the court. He basically followed along the lines of Article 6, Paragraph 2, which says the Constitution of these United States and the laws in pursuance thereof, and the treaties made or which shall be made under the authority of these United States shall be the supreme law of the land. The judges in every state shall be bound thereby. Anything in conflict or repugnancy to the Constitution is null and void of law. He went on further to say that no courts are bound to uphold it, no citizens are bound to obey it. It operates as a mere nullity, a fiction of law. It is not binding in law, okay? Now, technically, that case has never been overturned. So, technically, your rights under the Second Amendment were infringed upon, right?
Yes, sir.
Now, who says so? Do you say so?
I say so.
All right. We go now to Byers v. United States, 273 U.S. 28, which basically says that the Constitution is to be interpreted to include every word, every phrase, every syllable, to include the punctuation, to include the intent of the framer who made it, and then it shall be liberally enforced clearly in favor of the clearly intended and expressly designated beneficiary, the citizen, for the protection of rights and property. Obviously, they did not interpret it in your favor because they arrested you and charged you with a crime. Got me?
Right.
Are you seeing where I'm going with this?
Yes, sir.
They're the ones that broke the law. They're the ones that broke their oath of office. You have a lawsuit against them. You can go after their bonds. You can do all kinds of things.
Okay.
I'm asking you, do you want to do that?
Most definitely. I'm mad as hell.
All right. Well, then you need to get with the truth, and I will try and get you paperwork and programming and a lawsuit situation where you can actually walk through this. It'll put you light years ahead because if you had to do all the research I did, it'd take you 25 years, okay?
Okay. A lot of veterans are coming to me, and they're in the same situation.
Okay.
Because I was in prison, the 61st day of incarceration, according to Public Slip Law 105, says you can no longer receive any funds from the Veterans Administration because you received a felony. And I
can help you with that, too. I can help you with that, too. We'll get the case vacated. We'll get the charges dropped. We'll tell them if you don't fix it, we're going to file a $500 million lawsuit, and we'll attach everything you own, bank, business, and home. And either you cooperate and clear my good name and expunge the record and give me back my property that was lawfully not lawfully taken, and you put my status back and expunge and clear my good name, or I'm going to sue your socks off for violating my constitutional rights under Title 42 United States Code, 1983, 1985, and 1986, and I got a lawsuit with 86 counts of all the ways they violated your constitutional rights. Now, you get with truth. You get me an address that I can work to, and I'll get you the date.
Thank you, guys.
Okay.
God bless.
God bless you. Thank you for serving our country.
Thank you. Yes, and we're going to move on.
Thank you for coming home in one piece, too.
Yeah, really.
God knows there's
okay, Sir Ryan.
Didn't make it there.
Oh, I'm sorry. Sir Ryan, go ahead. Did you have a question?
Yeah, how would someone get a hold of the judge's oath of office?
All right. You go down to your state Secretary of State's office or your county clerk, and you ask for the oath of office of that judge. Within 5 minutes, he will get a phone call from that clerk saying, Judge, there's somebody down here looking up your oath of office. And when you get to court, he's going to be a whole bunch nicer to you. I've even gone so far as to go to records and deeds and looked up all the property of the judge right before a hearing. The judge called us into chambers and he says, "You're not thinking of liening my property, are you?" I said, "Well, that depends on you, Judge. If you're going to violate my constitutional rights, I'm going to lien everything you own, bank, business, and home." "Well, I wasn't even thinking about doing that." "Okay, well, then I'm not thinking about liening your property, but I have a list of it just in case." And the attorney started taking God's name in vain and all this stuff, and I said, "Excuse me, Your Honor, are we still in the presence of the court?" And he said, Yes, I'm the court. Even though we're in your chambers and this is a private meeting, he says, "Yes, I'm the court." I said, "Well, Judge, I wish to advise you of a felony. This officer of the court keeps taking the name of God in vain in the presence of this court, and that's a felony in the state of Michigan. That would be 750, 101, and 102, and I'm advising the court of a felony." And he turned to that prosecutor and told him, "Shut up, don't say nothing, I'll tell you when you can talk." And on the way down the hall, he put his arm around the prosecutor and he says, "No, look, that kid knows some heavy shit. You watch your mouth when we're around that kid, you hear me?" And the bottom line is we got to the hearing, they dismissed everything, and they treated me very nice.
All right.
So there's a lot of political games you can play with a little bit of cleverness and a little bit of persistence. Go down to the court, find out where that judge's oath of office is, go in there and look up his oath of office, and go over to records and deeds and look up all his property, get a listing of all his property, and when you get to court, you're going to find he treats you real nice.
All right, well, that was my only question.
Okay.
Thanks.
God love you.
Thank you.
Now, if you want to go after the bond, you got to go down to the treasurer, because all the bonds are held at the treasurer's. And you ask specifically for that judge's bond. Now, here's what they've been pulling lately. The judge doesn't get the bond anymore. He relies on the blanket bond for the theft protection for the city. In other words, the city has all their employees in a blanket bond that goes through some big insurance company, and if it's determined that employee is caught stealing or doing something illegal, immoral, or unethical, that insurance company coughs up the tab for the damage. Got me? Well, now these judges who are required to go out and get their own bond for their own specific performance have decided to hide under those civil insurance bonds. And they're not going out and getting their bond. Gee, MCLA 8511 says that the judge, within 10 days of the election, shall go out and get his own bond. You mean you didn't do that, Judge? Isn't that a breach of your right to hold your office pursuant to MCLA 201.3.7, which says if you neglect to file or take the bond within the time and in the manner as prescribed by law, you vacate your office? They don't like it when you talk like that. They get very tense. But when you get over to the treasurer's office, he's going to say, "What do you want that for?" "'Cause I do, and it's public record. And that judge has violated my rights, and I'm going to seize his bond." That will be back to the judge within 5 minutes. The next time you appear in front of that judge, you'll see a different person, unless you got just a complete idiot for a judge. And that's happened before, too. Sometimes these judges get to confusing themselves with God. I have a feeling that on the last day, they're going to have a rude reaction when they find out God takes a real dim view of that. Okay.
We move on. Yes. Cleveland, go ahead. Did you have a question for our special guest?
Hello.
Yes.
Hello.
I just want to say how much I'm enjoying your show and the Constitution Man, and just has really been very enlightening, and I really, really am enjoying this particular call. I have one question. I am from Ohio, and I am in foreclosure, and one of the docket entries that the judge had made in my case, as far as I believe it would be classified as standing, that the opposing side had, through their own title company, had supplied a title search, and therefore, she said, the opposing side has true standing.
Nope. They don't have it. They have to possess the note, the wet ink signature note.
Okay, they have supplied tons and tons of copies of everything, and for
Doesn't count.
The judge is not enforcing it. What could I do?
Then you're going to have to hold that judge to the standard of the law, because the law says what a holder in due course is. Look up that UCC 3-203 and 3-202(2) and then 3-405. That clearly establishes what constitutes a holder in due course, who has the right of enforcement of the contract. They have to have a copy of the note, and what signatures are acceptable for that.
So you're saying because, as I said, the judge had put in the docket that their own company had done a recent title search, and therefore they are the real party of interest. That is not acceptable.
No.
And what
I want to see the affidavit where they're swearing that in court. They won't give it to you because they don't want to go to jail for 5 years and get a $500,000 fine.
Well, I've been fighting this case on my own for about 4 years, pro se. And
okay, well then you know it's a real,
snake
den.
Oh my God!
Can of worms.
Well, in Ohio though, we've had that recent change. I don't know if you read about it, about affidavits regarding.
And you know who pushed that? That Attorney General down there in Ohio, because he's mad as hell and he's not putting up with these crooked bankers.
Are you talking about Richard Cordray or the new Attorney General?
The new Attorney General is hot on them like stink on doo-doo.
Mike DeWine?
The new Attorney General, the latest one. He's really hot on them.
Wow. Well, that just happened. I know about the affidavit thing. And
you need to look up cases like there's a Bokomo case. There's a case with a German bank.
Deutsche Bank?
Deutsche Bank. There's a couple of cases down right from Ohio. Now, if you get with truth, I'll get you copies of those cases. Those cases clearly lock them to a standard of standing.
Because that is my bank. That is the bank. And they've already had the sheriff's sale. And mine is, I'm not giving up, as you said, but the sheriff's sale has proceeded. I don't know, what exactly should I file?
Did they give you a notice when the sheriff's sale was happening?
It was already. It was 11/22.
Did they give you notice to show up if you wanted to show up and bid on your own house?
I don't think so, but I'm not
Check
sure.
on it. Because if they didn't give you notice, guess what? They violated your due process. Title 5 to 706, they got to do the whole thing over.
What is the actual notice called?
They actually put it on your door, where they give you notice of the exact date.
They put it on your door.
You can show up if you want to. If you want to show up and bid on your own house, you can show up. Did you have that opportunity?
But is it normally put right on your door?
Right on the door, and they usually take a picture of it too.
Or I've never heard that, but I mean, you're positive?
I'm telling you, that's the way it's done, and I've been doing this a long time.
And it has to be put on, because nothing was ever put on my door, ever.
Well, then you weren't posted, were you?
So then that's violation of my due process?
Right. Title 5, Section 706. Look it up. You'll see I'm right. Title 5, Section 706. You have a right to trial de novo. The whole thing has to be done over.
Okay, what's the motion called?
You're motioning for a trial de novo. You want the whole thing done over.
Because I wasn't...
Pursuant to Title 5, Section 706.
I gotcha. Oh, wow. Well, I'm a layman at it, but I keep trying and trying.
Well, you get with Truth, and we will get you documents that will help bring you up to light speed.
Okay, now, as far as getting with Truth, I've tried that. You mean just by emailing her? Is that what you're saying?
Yes. Get online, get with her, and she will have documents that I can get to you that will show you all this stuff.
Okay. Because I know
a lot of my cases come from Ohio. The best cases that you can get in the country are from Ohio.
Oh.
That Deutsche Bank case, that Bokomo case, all of those cases come from Ohio.
Because I know I went on to Angela's site, and then got into Truth's site, and I have emailed Truth a few things, and I guess I know she gets thousands of emails, and just nothing.
Well, also, you need to understand, these people put their pants on the same way you do, one leg at a time. They're not God. You got to give them a little chance and a little bit of time. And know that they're working 24/7. A lot of times they barely get a chance to go potty and eat food and take a shower. You know what I'm saying?
Now, is there any books?
Cut them a little slack,
There was a book that you had mentioned in the very beginning of the call. Was it called The Federalist or The Federal that you stated?
Federalist Papers. The Federalist Papers by Madison Hamilton and Jay.
Okay, and that would be the book regarding some good Constitution rules.
Yeah, and the intent of the framers pursuant to Cohen versus Virginia, 6-2-1821, which says that the intent of the framers is the law.
Right. Well, God bless you, and I appreciate all your information, and very kind and very nice to speak to all of you, and I'll let you go on with other calls.
Excuse me, before you go,
you
thank you.
You can't reach me?
Yeah.
You implied that you can't reach me?
Right. By email.
Do you have the correct email
Yes,
address?
I do, because I went right to Angela's site, and then I clicked on, and there was only like one small page, and then your email address was at the very, very bottom. And I've emailed several times, and this was probably, well over 2 weeks ago. So
and none of your emails have come through?
I'm sorry, you're both talking. I'm sorry.
Go ahead.
None of your emails have gotten through?
It said that they were sent, but I've never got any type of response back. I'm just wondering how long, just because I'm at the 11th hour, I'm at a real critical time frame to get any
All right,
help.
well, I'll tell you what. Here's what we can do then. You'll have to give me your number, and I'll have to call you and work some way around it.
Okay.
If you're at the 11th hour, you may have to take a drive someplace, and we may have to sit down and have lunch.
That would be great. That would be great. That would be absolutely wonderful.
We'll have to give a number to
just give it to Angela and let Angela give it to me.
They'll get it to you, and then you get it to me, and I'll do my best to try and work something
out. Oh, my God. You're godsend.
All right, listen. In the subject line of the email, put Cleveland.
Okay.
And I'll know, and then write in the email, send this number to the Constitution Man and Truth.
Okay. So I'll send it to you, Angela?
I might forget. I see so many emails.
Okay. So I'm not sending it to Truth. I'm sending it to you, Angela?
But I don't understand what everybody's email get through to me. I don't understand why yours isn't.
I know that it was like, quick couple sentences, and I had, like I said, went on the site, clicked on guest speakers, came into it was just one page of a few, I don't know what the topic was or whatever, and then your email was at the bottom, so I knew I had it correct. Took my time to put it in correctly, and I just have not heard back on my email from you.
Here's what I suggest.
Okay.
You do an email to Truth and one to Angela. One of those is going to get through for sure.
Okay.
And I'm going to get programming and get some way of contacting you, because we don't want people harassing you and playing games with your mind by blurting it out over the air. Okay?
Right. Okay.
I get it to them, and then they will get it to me, and I will try and work something out with you. You may have to take a drive and meet me someplace.
Are you in Ohio, sir?
I'm all over.
You're all over. Okay.
I cover probably 8 states in a 14-day period. Here, I'm there, I'm everywhere. Now you see me, now you don't.
Okay, I appreciate all of you and bless you for all your help, and hopefully, between us all, the great minds will all stick together, not quit, stick it out, and hopefully save my home of 32 years.
All right, well, we can actually help you, but we need to actually sit down and make sure you got the proper programming so that we can do this.
Perfect. Thank you, and bless you all.
All right, God love you and keep you.
Thank you.
You're welcome.
All righty. And now we'll move on to Who Knows Truth. Go ahead, Who Knows Truth?
Yes, can you mute? Quiet.
Yeah.
Yes, hello. Hi.
Hello.
Hi. My husband received a call from a collection agency a few months ago saying that he owes the state of Ohio for the year 2005 and 2006. And the thing is he never lived in the state of Ohio in those years. He left in 99. He left in 99. And we've discovered that this has ruined his credit rating. Because
we're going to fix it. First of all, you're going to ask him to verify the debt under Title 15, United States Code, Section 1692 parens G. That's 1692 parens G of Title 15, which is the Truth in Lending Law. They got 30 days to do it. If they don't do it, then you're going to demand that they take it off of your records, or you're going to sue them. And then they're just going to do that, or they're going to get sued.
That's great. Okay. We've started doing that. We actually notified the collection agency of that law, but we haven't gotten to the state yet. But here's the puzzling
thing. Tell them to make sure of the name, because I actually tracked down a gal the other day in one state, and there was 19 gals with the same name in the one state. So mistakes happen all the time. They do.
Okay, we'll do that.
I had another guy. They came and tried to sue him for a whole bunch of money, and the guy they were looking for was with the same name down in Florida. It wasn't even him. See, these people, and I'll tell you another secret, and this has been before the Congress of these United States, and they hauled the IRS down and made them sit down and go over this procedure for liens and levies. And in 98% of the cases, they found that the IRS was negligent in both procedure and proper due process in filing these liens, that they screwed up, that they didn't do it right, and that they violated the parties' rights when they did it, and they had to rescind the liens and levies and apologize to the people and pay them their damages.
Well,
so
here's
don't
the
ever
thing.
assume just because they put your name on a piece of paper and it comes from them that it's correct, because that's not necessarily true.
Well, that's what we're thinking. He left the state in 99, and they're billing him for 2005 and 2006. But we've discovered in his credit report that there is a I don't know if I'm pronouncing this right, precipice.
Precipice is a notice of hearing.
Right. Well, he was never notified. Evidently, they must have been sending it to his old address in Ohio. He hasn't lived there since '99, but he
First
he have been notified?
First step is we have to verify they have the right guy, number one. Second step is we have to verify they have the right numbers. The third step we have to do is, are you willing to fix your records if we have found there are errors? If not, then I have no choice but to litigate. I'm giving you a fair chance to try and fix it now. If you can fix it and you can show me, I'll pay the damn thing. But if you can't show me and this is all the wrong party, you better fix your records immediately because I'm being injured. And we sent him a curt little letter to that effect. Now, I'm trying to be a reasonable man. I'm giving you every chance to fix it. You got 30 days. If you don't fix it in 30 days, lashes incurs, and if you damage my name further, I will sue you.
Okay.
If you send a letter like that, you get their attention, believe me.
But
I send it to their chief executive officer, whoever that is. Find out who their chief executive officer is and let them know.
How do you do that?
Of the state? The chief executive officer of the state or the...
Of that company.
Oh, of the collection agency. What company are we talking about? The collection agency?
The one that's on the letter that sent you the bill.
Well, okay. But my question is in regard to the precipice. Shouldn't he have been served? I mean, a judge.
Well, yeah. First of all, let's explain to folks what a precipice is. A precipice, in real simple language, is just a notice of hearing.
But
That's what a precipice is. That's all it is a notice of hearing. So the law burdens the plaintiff to make sure you get the notice of hearing. And if they didn't get you timely a notice of hearing, the case is voidable ab initio from its inception. If they didn't serve you properly, that's one of the best ways to get out of a lawsuit is they never served me, Judge.
They never
served me. The judgment is void. The service was improper. They never served me. And you give an affidavit to that effect. Now they have to give an affidavit to counter your affidavit. Now, you file a false affidavit in a court of law, you're looking at a serious penalty of serious money in jail. They will think hard before they file a false affidavit coming back if they're not sure.
Okay. Well, they've already entered a judgment.
They've already entered a judgment.
Yes.
Well, we're going to void the judgment.
Okay.
We're going to ask them to clean up the record with your guy's name.
Right. Right.
You got two choices. You got 30 days to either validate your claim or get off my case.
Okay.
That's what's involved in that Title 15 United States Code, Section 1692, parens G. You know how to look that up at a library?
I think so.
You go into the books that are the U.S. Books. They're a maroon, kind of a dark maroon with gold lettering. You're looking for the book that's got a 15 on the back, okay?
Yes.
Then you want to open the book until it says Section 1692, parens G.
Okay.
And that's the exact law you're going to be quoting, and that's what's called Truth in Lending Law, TILA.
Okay.
Is
that part of the United States Code?
30 days, yep.
Yes,
and
it
they
is.
have 30 days to validate the debt. If they don't do it, they waive their claim.
Okay.
For those of you that are computer literate, can go on law at Cornell and do the same thing.
Right. You can go right online.
Yeah.
You can call it up.
Title 15, Section 1692G is the FECP.
It'll pull it right up.
Don't know.
Yeah.
But is this a common practice in precipice, not to notify the descendant?
No. It's required that they notify you. The burden is on them to notify you, or otherwise you're not properly served. Most judges are clever enough, knowing that attorneys sometimes do shady stuff and don't do their service. They do what's called a sewer copy. One copy goes with a sewer. That was your copy. So you never show up in court, so they never have anybody to contest against, and then they report you as a party who's in default because you didn't show up.
Well,
so then the judge will say, I want you to go out and serve them and verify your service with personal service. I want an affidavit from the process server saying that he actually personally served the party if he suspects anything's shaky.
What if they tried to serve you at your old address? I mean, they have the old address. They lived there years ago on this precipice judgment.
Well, they did it wrong. They obviously had a chance to verify service, and service wasn't verified, so guess what? What they'll do a lot of times is if they can't get a hold of you, they'll say they nailed a copy to your door of your last known address.
Correct.
It could be an inadvertence, an honest mistake, but I don't think so.
I don't think so
some
either.
lawyer was being slick.
Okay. Well,
Right.
that was
now, your
my
way of
main
handling
question.
it is you're going to contact these people. You're going to tell them to verify that pursuant to Title 15 United States Code, Section 1692, parens G. They got 30 days. They don't write you back within 30 days verifying the debt. We're going to write them a letter of default that they didn't answer timely within the manner in the time prescribed by law, and therefore you consider the matter closed.
Okay, great. We're going to move on.
Well, they may get pissed off. They may try and sue you. You don't know. But they're going to have to find you, and then actually we're going to go to court. And if they don't clean up your name, you have a right to sue them, and they won't have any defense if they've gone past 30 days. So they better get right on it.
All right. Timma, you have a question. Go ahead.
Hi, Angela. Very good show. Here's my question. About 1,000 days ago, my wife went to work. She was suffering from a condition of thyroid, hypothyroidism, which was causing some word communication problems. Her family intervened, labeled her mentally ill. She's fine. She's working a full-time job. She was put in a hospital. They immediately drugged her. Within, I don't know, a couple of months, they held her at this hospital against her will and appointed a guardian. And the guardian has taken the measures to take her away from her house. And I'm a common law husband of over 12 years. She's never had any problems, any histories. We've never had any histories. But
is this lady very wealthy? Is this lady very wealthy?
She has a brother that's a diplomat that doesn't like our political, religious, and our health care beliefs. So we were kind of like they were in opposition. They believed in doctors and psychiatric medication, and everything is fine. And we were more into
this is one of these cases.
scriptural health care. But anyways, the guardian has decided to place Patricia, it's been 2 years now, in a nursing home at 57 years old. She hasn't had treatment.
Can you talk to her?
They've taken her phone out. They take her mail.
Do you get to see her?
I haven't seen Patricia in over 2 years, about 1,000 days now. Nobody's allowed to see her unless you're on a list, which is the people that did this to her, which do not go and visit her. So she's been isolated, and they showed that she was what they've resorted to, since she was in such good condition. The insurance company gave her a light label of dementia, which she does not have. So now they've resorted to forcibly drugging her to shut her up because she was acting too coherent and too capable.
I should tell you that those drugs all have bad side effects too. Those Thorazines, there's Zyprexa.
They're killing her. Yeah, they're killing her, literally, because she was writing letters explaining abuse, and once they found out about these letters and over 1,000 phone calls, they pulled her phone out.
All right. Here's what we got to do. All right, this is a very special case. It's involved. It's going to take you sitting down with somebody like me, and we're going to have to physically go through everything and figure ways. Now, you're not the first one that I've helped. I've helped a bunch of people get out of mental hospitals, including myself, because they threw me in a nut house because I was demanding they uphold the Constitution. Okay.
Well,
I know what this is all about. I know what they're pulling. As a matter of fact, one of the psychiatrists refused to certify me as psychiatric debilitated because on our first meeting, I asked him if he had an appointment. And he said, what? I said, do you have an appointment? You're not on my docket. My girl has not got you on my docket. Why are you here? I'm the psychiatrist. I'm here to see you. I says, I don't have an appointment. Do you see people without an appointment? He says, well, no. I says, neither do I. And he actually wrote that I was sane because I demanded an appointment. Yeah. I tell you, I have been through some stuff.
Article 81 mental hygiene law is totally in opposition to our religious beliefs because psychiatry in its nature is not based on any facts.
Are you a Jehovah's Witness by any chance? Are you a Jehovah's Witness?
No, we just are simple people. You know, we're kind of people that pray.
Jehovah's Witness go to court and fight these kind of things. A lot of the cases that I get that are winning cases come from because some Jehovah's Witness had the guts to go to court and sue the bums. You know.
Well, they did use that in court against us. The attorney was accusing us of being in a religious cult, which really existed because we listened to shows on the internet, and that's how they tied us into
calls for a conclusion with no substance, in fact.
And then they accused
Actually,
me.
what I'm hearing here is a lot of religious discrimination. You know, that's a felony. Title 42 United States Code, Section 2000A. You know, we can,
the Guardian that
we
was
could lay
appointed
stuff on them like you wouldn't believe, and you know, I'm up for the battle for that kind of stuff because I hate it so desperately for what they do.
Well, you're right about the religious, because as an injury to insult, they appointed as a guardian the Catholic Family Services.
Really?
Which, on purpose, which is as a corporate entity, I don't really understand that.
Well,
but
we can go into all these little tight, what they call fly dung on a pepper arguments, but I'm telling you, something has to be done on this, and you're the one that's going to be the one to do it. So we have to figure a way to get you identified with truth, and she's going to have to get me your paperwork.
Excellent.
So that we can do something to help your gal. I'm very, very knowledgeable about getting people out of nut houses. I got myself out 6 times.
Well, the people that are involved are a cast of characters that it's like a gang of a small group of them. And I think ultimately when you talked about the money, I think what they probably have done is put a corporate life insurance policy out on her corporation.
Whatever.
And
we will get to the bottom of it. We will get to the bottom of it, and then we will pull their chain.
Thank you so much.
In the meantime, you have to be very kind now to this gal. She's been put through a lot of stuff. I would definitely recommend you make attempts to see her. God only knows what they're doing when you don't see her.
Well, they won't.
If somebody's coming to see her, then they have to make sure that she's not beat up and stuff like that. See, behind the scenes, they sent 15 guards to beat me up to take the medicine, and I told them, I said, I don't think you understand. I'm a Jehovah's Witness, and I don't do corruption of the blood. That's against the Bible. Right. You either take the drug or we're going to hold you down and make you take it. Well, for 43 minutes they found out this old paratrooper, you just don't jump on this guy because he whoop your ass. And the big guard says, how old is that old man? And the nurse says, he's in his 60s. The hell you say? Did you just see him throw my 6'3" Charlie through the air like he was a paper plane? They didn't get me down until they did the shock taser gun. And then they gave me a heart attack, and I had to go to the hospital. Well, they fixed my heart attack, and then when the doctor saw how bad I was beat up and then I was a Jehovah's Witness, he filed a complaint with the sheriff who was coming down to arrest him for abuse of a prisoner. Now, I know about these things. I know a lot about these things. I'm not trying to scare people out there into not doing their duty. I want you to do your duty anyway. I'm just saying that a lot of things have happened, and we have to put a stop to this. And this particular case is an exact example of what we have to do. We have to get on this. We have to catch these people in what they're doing. We have to pin their hide to the wall, and we got to let them understand there's going to be consequences if you don't release her immediately. I had a Jewish rabbi that they threw in a hospital only because he was an outspoken rabbi and told the truth, especially against the government. So they threw him in a nut house. So I went down and got him out. Now, the reality here is he was a person. And he was being railroaded because he spoke the truth, especially about some of the illegal stuff the government was doing. So they threw him in jail and in the nut house. Now, the reality is there's a lot of good people out there that are trying to fix this, okay? And we have to pay attention and try and help those that are being railroaded like this. That's required. And I don't care if they're black, brown, green, white, yellow, Jewish, Christian, whatever. When they are abusing people like this, we need to put a hook on them and tell them, hey, this is unacceptable. Period. This isn't Nazi Germany. This is these United States of America. We don't do that here. Got me? And I don't want to hear that you're just following the orders of your superiors. They tried that at Nuremberg. All them guys got hung because what did they say? No, there's a higher law, and that's God's law. And clearly you knew or should have known when you pushed them people in them poison chambers that, you know, you were murdering people, and God told you you can't do murder, you know. You should have listened to him. He was right. Now we're going to hang him. See, that excuse, I was just following the orders of my leaders, that don't get it. No,
That's what happened.
They have to be responsible and understand these are human beings that are doing this stuff too, and we cannot allow this.
That's what they did the day that she went to work. I called the police and said she was kidnapped. They showed up at the house about an hour after, or a half hour after I went to the police. They told me to wait at the station, and I came home. The police were all there with Pat there. She had told the police she was being kidnapped. They forced me to come into my...
Did you ever go to court?
Did I ever go to court? No, I never... No, I never. This has gotten so convoluted. I put that as a side issue. My main concern was getting Pat her freedom, and it's just been piling on from one agency as another. But, you know, she did tell the police she was being kidnapped, and I was right there, and the cops looked at her and goes, "You shut your mouth." And then the diplomat looked at me and said, "You're lucky I don't have you arrested for saying we kidnapped her." And that's the last time I really seen her. I have been able to talk to her.
All right, this is what we call a big case. This is a big case. We're obviously not going to answer this tonight on this phone, obviously. So what I'm going to recommend you do is get in contact with Truth, get me your paperwork and at least your way of getting a hold of you, then we're going to have to make an effort to sit down and have lunch and go over this whole thing. This is a big case, and obviously they've done great unlawful things and unconscionable things to your gal, and we need to put a hook on this somehow, some way, get a handle and a way to fix it. Worst comes to worst, we're going to go after all their bonds and what have you and their oaths of office, and we're going to do whatever it takes. If I got to lien their bank, business, and home, whatever it takes. I had a young state trooper, he thought he'd be real clever, and he's going to harass and harass and harass. The guy just kept going and going and going. I told him, I said, look, you better knock this off or I'm going to have to do something. Well, he didn't listen to me. So I filed a waiver of tort against him for $100 million, and I seized his $288,000 house in Livonia, Michigan. And I put the damn thing online on a common law lien, and the next thing you know, his wife beat the hell out of him with a broom handle, so he got busted for domestic violence. He couldn't have a gun no more, so he couldn't be a state trooper no more, so he lost 20 years. All right, okay. All right. All right. All right.
Thank you.
Anyway, he lost his house, he lost his job, he lost everything. He works as a security guard now, and he had 20 years in with the state police. So I can't tell you how to fix this tonight. It just can't be done. We're going to have to sit and do it, okay?
Thank you so much.
All right. God love you. Get your...
Praise Yahweh.
Get it to Truth, okay?
Thank you.
All right. God love you. We're going to have to wrap this up pretty quick, so can we get, say, one more call?
Okay, just one more. We have 15 people waiting in line.
Oh, my God. All right. Let me see what I can do here.
Okay.
I'm running out of battery. I'm running out of batteries.
Oh, no.
And I charged it for an hour or two. Okay.
Do you have another one?
No, I don't. That's the problem. We don't ever go this long in one place.
Well, is there a possibility we could do a continuation of this on another day?
We could.
Well, of course. Sure. Well, I mean, it's okay with me, of course.
Ask you your question, people, if anybody has a really super important where they got to have an answer right now.
Oh, I don't know how I would tell.
Oh. All right. Well, why don't we set up another day then and try and wrap this up for tonight because I don't want to
be
half in the middle of something, and then we get cut off.
I know. Do you think you take one more?
I'm getting flashes right now. All right, we'll try it, but I can't guarantee you we won't get cut off, okay?
All righty. Go ahead, Dave.
Go quickly because my battery's flashing.
Hello, can you hear me?
Yeah, go ahead.
Okay, real quick. Couple things. First of all, thank you for your service. I'm a Vietnam veteran also.
Good job. Good job.
Void
highly
judgment.
Trained, highly motivated.
Well, we worked at it. Void judgment. I have somebody that's got 3 judgments on credit cards. What is the best thing you can tell me to go about voiding those judgments because they're trying to sell some property without having to pay out almost $40,000?
First of all, have you notified them? Have you notified them under House Joint Resolution or under Truth in Lending under Title 15 United States Code Section 1692G? Have you notified them?
No, nothing yet. These people have come to me. I'm going to assist them. That's what I do.
Okay. All right. first you have to notify the party that they've injured you, okay?
Okay.
Second, you have to give them a time to fix the injury if they're gonna do something. They got to fix it, okay?
How much time do you need to give them?
I would give them 14 days to 21 days. Usually most state law is 21 days.
Okay, this is Texas.
All right. Well, look in your books and see what they give you for standard. In Michigan, it's 2.108 B as in boy. You got 21 days or 28 days if it's served out of county, okay?
Mm-hmm.
If they don't answer within that time, default them.
Okay.
Then, if they owe you money and they're not paying, you give them notice of intent to lien and give them another 10 days to answer that.
Okay.
If they don't answer within the 10 days, then you give them an immediate affidavit of non-response. And then if they still don't respond, go lien everything they got, bank, business, and home.
Okay.
Okay. And they usually have their attention before that.
Yeah, I would think so. Well, this is an elderly couple that I'm going to assist. The other quick question, this is something...
I'm going to lose this battery.
No, okay. Clearing original creditors out of the credit bureaus.
Okay.
Best way to do it.
100 cases here, where I could give you a different one for each one. I know.
Maybe that's something for another night.
Well, I'm going to have to cut off here because my battery's dying.
Okay. So, let's take that up on another night.
All right. Thank you so much.
That's going to be big. That's going to be big. Okay.
Yes, it will. Thank you so much.
All right. God love you and keep you now. Like we are all on the same page now. We all know what's got to be done, so let's get out there and do it, okay? And it's been my privilege to be here. God love you guys and keep you.
Okay.
Thank you so much, Constitution Man, for coming on. We appreciate it. Thank you, Truth. And we'll have you on again real soon.
All right. God
Thank
bless.
you so much.
Bye-bye now.
Okay, bye-bye.
Thank you.
I really want to thank you very much. And, Dave, you can get that information from me as soon as I get it from him. I will transfer it to you. I don't have a problem with that.
Okay.
A lot of this information that you guys are asking for is going to be posted on myprivateaudio.com. You do have to wait until I receive it, though. I can't post it before I get it. But his notice of waiver of tort and intent to lien, it's already there. It's already on the page. Some of this information, you have not gone to the page to see what's posted. Okay? Hello?
Yes.
Yes,
ma'am. It just sounds like everybody went through that.
No, I'm listening.
But you should know that I don't have a problem sharing. That's the whole purpose of the call, is for me to share with you my direct source.
Mm-hmm.
I'm not trying
and you have been sharing with me, and I appreciate it. Everybody needs to understand she will share this information with you. Please contact her if you need help, because I'm in daily contact with her. So there's a lot there that she can help with.
And I'm just saying, when I want to know somebody or locate someone, and this gentleman had some very valuable information that I personally needed to do something, I put my feelers out till I found somebody that knew somebody that knew somebody that knew him, that put me in contact with him. And usually that's the way it is. If I want personal contact with somebody, I do my due diligence. I ask around. You have to do your due diligence and do your investigation, which is how I came to find out his contact information. He reciprocated, and I had to go through the state of Texas to get his information. Just FYI.
Whatever it takes.
Right. I had to know somebody that knew somebody, and that's real. Meanwhile, I definitely want to mention my peeps down in San Diego at AAEC, 4715 30th Street in San Diego. Max Mason, the gentleman that could tell you exactly what I've been trying to tell you about the trust, the IBCs, the LP LLCs, the C Corps, the whole nine. He does presentations every Saturday from 2 to 6. I want to give his staff, he has a wonderful, wonderful staff. I want to give his staff a personal shout out, and that's Ann, Debbie, Julie, Lamage, Paul, and Susan. Am I forgetting anyone? They are a great bunch of people. They will accommodate you, answer any of your questions. They're not the type of people when you ask them anything, they get an attitude. They are very, very accommodating. And they really impress me. They know their stuff. They know about the history of money. They could tell you almost anything you need to know about corporations, send you to the Internet, give you the correct URL that you need to go to do your own due diligence, research, and investigation. And that's the guys at AAEC down in San Diego. You always hear me say, whenever I'm in California, I'm taking a group of people down to San Diego to get personal first-hand knowledge, so you don't have to take my word for it. And secondly, I'd like to say, would you please, those of you who would send Angela a $100 donation. I need 50 people to do that.
Wow.
I need 50 people to do that if you would. And she will forward your names to me, and I have something special for you. Now, this has nothing to do with the information that you've heard from the gentleman, our guest, but I'm telling you personally, their computer is like 10 to 15 years old, okay? And we're going to get him a new laptop, and that'll be taken care of tomorrow, and I'll get it, I'll FedEx it to him and overnight it so he can have that and come up to speed on some stuff. His hard drive is not even a gigabyte, it's megabytes, to let you know how old his laptop is. So that's one thing I want to take care of. The next thing is I need you to support Angela because I'm sponsoring her for the trust, but she still has to have filing fees. She still has to have deposit money for her account, and she's going to take that and share it with you. If you sow a seed into her life, she's going to sow a seed back into your life. And that's the law of reciprocity. That's how it goes. If you really want to be blessed, then you're going to have to learn how to work universal law, and that is you have to give. And when you give, guess what? You receive. And that's all I've been doing. That's all I've been sharing with you. That's all I've been trying to get across to you. This is about giving. And everyone that I will be announcing the names of the people shortly. And they're going to have direct contact with the people in San Diego. They're going to have personal first-hand knowledge, and they'll be able to come back and share it with you. You don't have to take my word for it.
That's for the people that you're sponsoring, right?
That's correct.
Good. Yes, I've been getting a few emails. I've been just forwarding them to you.
Right, and that's why I couldn't understand why the young lady couldn't. I've been calling everybody that has asked for sponsorship. I have my list together, and I was looking for 2 more people because I was going to forward to Max's office 12 names instead of 10. But I'm telling you, you still have to have some money to open these accounts and do the filing fees for the Secretary of State and meet the requirement for whatever country that you may be dealing with. I don't set the prices. These prices, if you did your research, are already online. They tell you exactly how much they want. To do an LLC in Nevis is $3,495. To open up a bank account and believe they want you to have a minimum $1,000 deposit. So even if I do sponsor you, you still would have to have some money. How are you going to pay the Secretary of State of Nevada to file articles of incorporation papers with no money? See, now, Max can tell you how to do it. I can't. That's why it's so important. If you want to give them a call, I believe their number is 619-269-8162. And you could tell them that, ask them if they can email you any type of information about AAEC program and how you can become a part of their family. And I mean, he got a great bunch of girls. He got like 6 girls that do a presentation. They give you the history of money, the whole 9 yards to the current time, and then Max comes out and does his presentation. I mean, I was very impressed, and I am not easily impressed. And you could tell when I'm not impressed because I be telling you, thanks for no thanks. I'm out, peace. You know I'm not impressed. Well, I'll be constantly saying, come on, let's go. Let's hit the road. It's time for us to go. You know when I'm not impressed. I have been to San Diego several times, and I've always taken people with me. And I'm just telling you, the information is so invaluable. Even if you can't do anything with it, at least you have a focus of when I get the money, I know where I'm going with the money. I know what I got to do. I know which direction to head in. And that's how. I'm sorry.
Is he going to participate in your online webinar?
I've asked him to, and he's told me he would consider it. So I'm still waiting on his definitive answer, and we'll see. But he is aware of the webinar, and of course, I want you to get it straight from the horse's mouth because nobody can do the presentation like his girls can. I mean, they're just perfect.
His contact information is also at the bottom of your webpage and also on the meetings events page.
Okay, so
if no one got it when you said it, then
right, it's no excuse because we're putting the information out there as fast as we get it, to try to help you. And I don't know what else to tell you. As soon as I get the information, I try to disseminate it because actually I'm not on overload. I believe I can handle it all, but what good is it? Every situation is not applicable to my life. So I need to disseminate it to somebody who can take advantage of it. And that's you guys. Everybody is an individual. Everybody is unique. We all have our own set of circumstances.
Truth, did you want to take some questions? There's some 15 people on here with their hand up.
Oh, sure. I'm sure they didn't want to talk to me, but if I can assist anybody, of course I will.
Well, let's see. I mean, I would gladly hear from you. You're like his right hand. Guest 55, go ahead. Did you want to ask a question? Maybe Truth can answer it for you. Guest 55. Oh, you muted yourself out again. There
Hello?
you go. Yes, go ahead.
Hi, Angie. It's Mark. Hi, Truth.
Hi, Mark. Hi.
How you doing? Hi. Couple questions for you, Truth. Mine are regarding contracting with Social Security to get the benefits and how to restrict that and control the contract.
I'm facing the same situation that you are, and I would have you made your application for the benefit privilege yet?
Yeah, I actually did it. I was actually forced to do it by a third party. I'm kind of a unique situation. I had a contract with a third party, and part of that contract was that I had to apply, and so And unfortunately, they approved me Social Security disability, and so the third party doesn't have to compensate as much as they normally would. They just deduct what SSDI has given me. So I'm trying to. So now I've got to twofold. Restrict the checks, restrict my signature, and on the checks, in addition to the actual application and controlling that contract.
Okay, hold on one moment. I was trying to copy something. Contact me in the private, and I'll tell you exactly what I'm doing, because this is my year to apply for the benefit privilege.
Okay.
And I was coming up with a plan of action, so I can get my Social Security, because I don't want them to have it without receiving their benefit privilege. So I'm revoking some signatures and some contracts, and I'm putting a notice and demand on them for all the money that they've taken with interest. And I'm sure you heard they have X amount of days to give me my money, or they're in default.
Right.
I'm going to default them and sue them for it.
Now, make sure I get
I'm going to default them and sue them for it.
What you're looking at doing then is that you're going to go after all that you're taking out. What?
I'm sorry, I couldn't hear you because of the.
I couldn't either. I couldn't hear what I was even saying. Let me repeat
I got it. Go ahead. Yeah.
Okay. So just make sure I get the gist of what you said. You're looking at going back and getting back everything that they've illegally taken from you over the years, or how to start getting the benefit without and still control the contract.
Well, number one, my contract was made. I was a minor.
Right.
Okay. So that's one thing. You can't contract with a minor. You know that.
Correct.
So I have that on my side. And plus, when I was coming up, my lawful age was 21. It was not 18.
Okay.
So I got my Social Security card at 15. So I had 6 years to go before I became a legal adult.
Right.
Okay, so I can now that I'm of age, I can revoke those contracts because they're void anyway because of the fact that I was a minor.
Yeah, that's one of the reasons.
I was a minor. So anything that was taken from me, I can request it back plus interest. And that's quite a number of years of worth of takings. You know what I'm saying?
Right.
So like I said, you contact me and I'll, because this is personal, I'm not going to go over it.
That's fine. No, I don't
call, but we can discuss it one-on-one.
I'd love to do that. What's the best? I know Angie. I've got her information. Angie and I know each other for years. I'll just give Angie a call and she can put me in contact with you.
Just email me.
Okay.
And put the Social Security number in your byline.
Okay. I'll just put that in the subject matter.
Right.
Okay. And then, take it from there. Great.
Okay. Thanks so much, Mark. I'm glad you made it on the call.
Thanks, Angie. Thanks, Truth.
Talk to you later.
Bye-bye.
Okay, Dave, are you in line again, or is that from last time?
Hello?
Hi, Dave.
Hi there. I didn't have another question. I was just talking to Constitution Man. I'll be talking to Truth tomorrow, and you can go ahead and take another caller.
Okay, great. Thanks.
Thank you.
All righty. Truth, can we move on? How many more can we take? We got a whole bunch.
Well, we could take them all.
Okay. Let's take them all. I like this woman. Go ahead, Trust Law. Hi, Carlos. Carlos, what'd you do? Okay, try it again. Say something. Trust Law. Oh, you keep pressing the mute button. Okay, now you're unmuted. Go ahead. Did you want to ask a question, Carlos? We can't hear you. Do you get the mute button on your phone, too?
Tell Carlos to call me. Yeah.
No,
you know,
what? What?
You could call me.
Did you hear that, Carlos? She said to just call her. All right. Well, we can't hear you, so we're going to move on. Guest 99, go ahead. You want to say something? Guest 99.
Hello.
Yeah, hello.
Hi.
Hi. Do you want to ask Truth a question?
Yeah, I had a question about mortgage, like a foreclosure, and you're asking for the note in court, and the lender says that they don't have it and file a lost note affidavit. What can you do about that to not let them use that as an excuse?
There's more than I don't know what part when you started listening to the call. You should ask for a receipt of the original fees that you did at closing. You ask for that receipt. You can ask for if you're in court, your property already went to church sale, correct? Or trustee sale?
No.
You're suing them?
No, that was part of they had a complaint, and so that's what we filed as far as the note and so forth, and they said, well, they didn't have it, it was lost. And that was their response to getting around that question.
Okay, but the key thing before you get to they don't have the note is their agency. Who do they work for? Who hired them? Who signed the contract? Where's the contract? And who's to testify to the agency? Because the attorneys can't testify. So somebody from that company has to come in to say that they have authorization to hire that attorney firm, and you have to be able to cross-examine them on the stand. They don't have a capacity to sue. There's no agency. You have to first make a proof agency. You know, you just can't come to court and say, I represent Bank of America. I don't think so. I'm a Bank of America customer. Are you serious? I want to see a copy of the contract. If you hire an attorney, you have to sign a contract. So if Bank of America hires an attorney, guess what? That attorney has to have a contract. Who signed it? Who gave the authorization?
Okay.
What position do that person hold? That person has to come to court to testify that this person has agency, because the agent cannot testify to their own agency. They have no capacity to sue.
Right. So they have to get an affidavit from whoever they work for to say that they're authorized. That's what you're saying.
Right.
So if they get that and
they have to bring a copy of the contract to court. That's what I'm saying. When you retain an attorney, you have to sign a contract.
And that's for a mortgage action, foreclosure action, right?
That's correct.
Okay.
And I meant to mention that Evidence Rule 901, and this is in every state, you have to have the original wedding signature document. You can't use copies.
Well, no, in the UCC they said they can do an affidavit for lost note.
Right. But it's 4 things they have to prove in the lost note. And I have to look that UCC up.
Uh-huh.
But it might be 3409. I'm not sure. Don't hold me to it. Like I said, I have to look it up. I'm just taking a guess. Okay. That is 3409. So it's in that vicinity about the lost note and the 4 elements that have to be met for a lost note.
Okay. Another quick question. This is Trevor, by the way, if you didn't know. I had heard or read that another possible way to deal with a foreclosure is to take the property and donate it to a not-for-profit. Are you familiar with that or no?
Oh, yes.
Okay, so do you know, like...
Truth, when you get a second, I would like to add to this caller.
Not a problem.
Sounds like the guy from the East Coast. So, can you give some basics on how that would work and how you would do that in court? And the reason why I mentioned it, I saw a lady in court this week, and she donated her property to the Moorish Temple of America, Moorish Science Temple of America. But she didn't, I guess she didn't write it, her motion or whatever correctly. And the judge seemed like he kind of understood what she was saying, but he said something about injury and remedy.
Okay. Well, you're asking about somebody else's situation. And yes, you can donate your property. See, the operative thing is it's your property. And no one can tell you what you could do with your property.
Right.
So if you want to quit claim it to somebody, if you want to make a donation to a church or whatever, that's your right.
Right. So how does that affect the foreclosure action?
It doesn't affect the mortgage. The foreclosure, they're foreclosing on the fact that you're defaulted on the payment.
Well, I'm assuming they're doing that so they can take the property.
Actually, the house is not on the deed. What's on the deed?
It's a mortgage.
No. What's the description on the deed? It certainly doesn't say it's a 5-bedroom, 2-story house on there.
Oh, they have a legal description.
And what does the legal description consist of? It represents what?
Some corporate numbers and zones and so forth.
No, you're missing the point. Okay. The land, it represents the land. The structure is not on the deed. It's the land that's on the deed.
Okay. So what, they can only take the land, is that what you're saying?
If you secure the land, then don't you own what's on the land?
Yeah, but how do you secure the land? Is that through a UCC?
Yes. You will put a lien on it. A notice of interest, an agricultural lien, a mechanics lien, a construction lien. You will put a lien on it. There's nothing you buy that they don't follow UCC on 3 days after you've made that purchase. When you buy a car, I'm going to tell you this, if you go buy a car and you follow UCC on that car the same day you buy it, they're following theirs 72 hours later.
Okay.
You don't have to pay for that car.
Right.
Because first in line, first in time. First in time, first in line. So, if they have a lien on the property, unless you have a greater lien, unless you have a notice of interest lien, sure, they can sell it, but then they have to still pay your lien as well. They have to satisfy all the lien holders, but the mortgage lien is on there first.
Right. That's what I'm saying. So if they have the mortgage lien first, how do you put a lien to supersede what they're doing?
The lien doesn't supersede. You could just ask for a greater amount of money. And I think I discussed this on a previous call. 1215.org has a beautiful maintenance invoice. You get to invoice them for the upkeep, the painting, the mopping, the cutting of the grass. You get to invoice them for the upkeep of the property. And that can far exceed what the mortgage amount is. And you get to submit that bill to them and ask for payment. You get to do that for every year you've been on the property or in the property or had possession of the house.
So
and tell them to pay you. It's a job. Tell them to pay you.
So how would you submit that into the foreclosure case?
You would submit it like you submit any other papers. You get it time-stamped and add it to the, put it in the evidence file.
Okay, so you have to do like...
You only do that after they defaulted. If you listen to the call earlier, they have to be in dishonor or default.
So you would have to ask them for payment before you did a cross complaint.
Well, if I want you to pay me, you're not gonna pay me if you don't know you owe me.
Right.
So you have to invoice them. You got to submit some type of bill and let them know. Then you want to sue me for this amount. I got a counterclaim in for this amount, and my counterclaim is greater than your original claim.
Got it. So that would go to the mortgage company or CFO for that particular company or the attorney's office for that company?
It would go to all of them. It would go to the attorney, the law firm, and the mortgage company.
Okay. And would it be directed directly to the CFO or no?
It should be directed directly to the president of the bank. The reason being the president serves as one of the directors. If you know the law, the bank president, all banks have to have 5 directors, and the bank president is a director as well as the president of the bank. You have to know the law. You just can't hop up and do stuff and you don't know the law that allows you to do it. That's what gets you into trouble. And the fact that you're not putting law into your case. Everything you say, of course you can do it, but you don't know what authorizes. Where's your authorization? Truth says so? I don't think so. What law authorizes you to do it?
So in this particular case, what would be the law that backs it up, or where would I go read this particular law?
You need to go read the UCC, number one. And I'm not going into this in particular on the phone. In case you don't know, Trevor, I don't know. If you do know, I do foreclosures for a living. And I'm not going to tell you my trade secrets for nothing, and I charge people for this, okay? I do this for a living. I am not free when it comes to foreclosure. Certain things I'll tell you about law, I don't have a problem with. But when you're treading on my livelihood and taking bread out of my mouth, it ain't that kind of party. And I don't know what kind of drugs you smoke, but send me some.
Well, I don't smoke drugs at all, but...
I was just being facetious, honey. I'm sorry. You didn't get it. I'm sorry. I wasn't trying to...
Yeah, sometimes I'm slow, but I got you.
I'm slow, too. That's what I'm telling you. I got stinking thinking.
Right.
I don't know nothing. Trust me. You think I know something. I don't know nothing.
Gotcha.
But with the nothing I know and the nothing that I'm fixing to get from somebody that we just talked to, I still ain't gonna know nothing.
Right. Gotcha. So yeah, I just figured I would ask about that as far as donating, and I heard that was a viable option. So.
Well, you can do it, and there's someone waiting to comment behind me. And maybe they'll give you, they do foreclosures as well. maybe they'll give you more insight. But me personally, no. I got 4 pending cases. You know, and I'm not going there.
Got it. Fair enough. Well, if that guy he wants to respond, I'd love to hear it.
Okay, you're on.
Okay. Good evening, everyone. I just wanted to add on to something Truth mentioned with regards to making improved agency, and it's something that people can utilize in the foreclosure process. It actually has stopped them in their tracks. As many of us may know, that a lot of these foreclosures are 100% fraudulent, that the entities that are foreclosing really have no authority to do so. They're not the real parties in interest, et cetera, et cetera. And so what I've been suggesting to people, we don't give legal advice, what we've been suggesting to people that as soon as you get any presentment from any entity, it don't have to be just foreclosure. It could be a third-party debt collector on a credit card, school loan, whatever. One of the first things you want to do is send that presentment back with a letter requesting that they prove their authority to act. Now, what that does, what you're telling them also is you're asking them that the proof has to come from the principal, not the agent. And if you go and look up agency, which Truth just alluded to, agency is proven by principal, not the agent. So therefore, you would request that they give you a wet ink certification from the principal, either a power of attorney or power of appointment, or anything that they have that allows that representative of that entity to act to show you proof. Otherwise, they have no authority to act. They can't prove it. You don't have to do anything. They have to prove to you first that they have authority to act. Now, if you do not challenge it and they go forward, then you lose your opportunity, or you may lose your opportunity to challenge it on that ground, but you can get it on other grounds with regards to they're not the real party of interest, et cetera. So we have stopped them in their tracks just asking for their authority to act. Because in a lot of the cases, these trustees' agents, these trustees, they are not proceeding correctly. And they're out there just stealing. There was one gentleman that had spoke to a servicer, EMC Mortgage. And they told him straight up, your beef is not with us. Go check those attorneys because we have nothing to do with this foreclosure. Another guy in Ohio had BAC. And he did some investigation. Come to find out, BAC had nothing to do with the foreclosure. It was the attorneys behind them. In Colorado, there's a scam going on between the judges and the attorneys with the public trustee, stealing people's houses, and that the entities that they're holding up in the public has nothing to do with it. So one way to prevent that is to immediately request for their authority to act. So that's all I wanted to add to that. That goes in line with what Truth was talking about, making them prove their agency.
Truth, I need you to press *8. I had a couple of Michigans on there making noise, so I don't know which one you are. There you are. Okay, thank you. Sorry about that.
Well, I thank you so much for adding to that, because sometimes when I'm explaining things, it helps when you get someone else to tell the same thing in a different message. And I really appreciate that. Non-guru, I really appreciate that.
Is your battery running out too?
Yeah, she's breaking up pretty bad.
I know. It's coming
No,
in and out.
My battery is 3/4 full. It's some background noise, but there's no background where I'm at.
Okay. Well, you were fading in and out, sort of, kind of. So,
well, I made sure I charged my battery. I learned my lesson the last time. With a few calls back when it just cut out on me. But, you know, we're telling you the basic principle. You still have to have the self-realization and accept it in your mind. It's not that complicated. These people are invading your privacy, and pursuant to law, they cannot invade your privacy without just cause. Plus, the importance of the Constitution, Article 1, Section 10, Clause 1. They cannot impair your obligation to contract. All attorneys have to take an oath to support the Constitution as well. When they violate their oath, they're committing treason. You have recourse. You know that they're fraudulent. You have the law on your side. Your remedy is in the Constitution. Learn the Constitution so you know how to use it.
Hey,
I ask them, are you meddling into my affairs? Do you have a power of attorney? You know, I fired an attorney once, and I said, you're fired, you know, for a client of mine. And, you know, she signed it and sent it to him. And he was so mad. He said, I don't work for you. You can't fire me. And I said, you know, I really would like to thank you for providing me the written evidence. And you articulated it and said it so eloquently. You don't work for me. So what are you doing meddling into my business and impairing my obligation to contract? And this is an invasion of my privacy and a violation of your oath of office. Can you imagine how he felt? See, I didn't have the written evidence, but by him calling himself being smart, telling my client off, he provided written evidence of his guilt, of his offenses. Now I got it in writing in his own hand. He don't work for me. It's not his contract. What is he doing? You need evidence. You just can't say stuff. You have to have evidence. Physical records. And that's the best way to get it. Fire them. Let them respond. We don't work for you. You can't fire us. That's what you wanted. You wanted written evidence. That's correct. It's my contract. So what are you doing? You don't work for me. So now I got written proof. You don't work for me. You're in my contract. What are you doing? This is my contract. You see, it's not really that complicated. We just, like the gentleman said earlier, we could do so much together if we just, you know, have a meeting and come up with some ideas and a viable way to do it. It is not that complicated. We are our own worst enemy. Our adversary is outside of us, which is usually the opposing counsel. But your enemy is in you. You're your own self-saboteur because you don't want to learn the law. You know, you want to do this, that, and the other because you heard somebody did the UCC. You heard somebody did an A for B, and you never did your due diligence to find out what's the correct way to do it. I didn't hear not one person ask the gentleman, would you give Truth the correct way to do an A for B, and would you give Truth the correct way to do a UCC? But you didn't have to because you know Truth going to ask for herself. Since you didn't ask him, I bet you when he contacts me, I'm going to ask him, well, what is the correct way to do a UCC? Well, what is the correct way to do the A for B? I wrote down the information that he promised people so I can make sure that he remembers to give me everything that was discussed on the call. But certain things that were said, you didn't ask, well, could you get at the Truth so I could get a copy?
They'll be coming in, I can guarantee you. The emails, they're already coming in for People wanting whatever you said. What was it? Arresting the bond and
No,
the traffic issue.
No,
and what the gentleman said.
Yeah, right. See, now you want me to give you everything, right? To get your little self in trouble. I was gonna put that on. I'm gonna post it on the web page, so you won't have to be. Everything that he gives me that I'm allowed to share will be posted. You don't have to continually write, well, Truth, I want you to share this. Truth, I want you to share that. The gentleman needs a new laptop. I think I mentioned that. So I'm going to get his entire legacy when we switch the old laptop to the new laptop. I will have his entire legacy, and I just thank God that it's an honor and a privilege for me to even be a recipient of such. And no, I'm not giving you his entire legacy that I'm getting. But what you asked for will be posted.
Are you still there?
Yeah, I'm still here. I hear feedback.
We're getting a lot of feedback again.
Yeah.
Yeah.
So, but what you asked for, what he said he's going to send you, I'm going to make sure you get it. But the legacy, I don't want you guys, to get yourself in trouble. It's just like giving a baby. I don't have a problem giving a 2-year-old a gun as long as you properly train him how to use it. Because if he can hold it and pull the trigger, you can train him to properly use it. And I know this to be true. When you start talking, if you could teach a baby to read and he can't talk or walk, you could train him to do other things the same identical way. So when he's in the position and he has the dexterity, he'll already know how to position the gun. He'll already know how to hold the safety or check it. There's a way kids demonstrate when they're ready to learn something. And I learned that years ago when you see a child playing with a knife. That's the time to teach them to properly use it. You don't want them to injure themselves. Oh, no, that's a knife. Give it here. That's the time you say, here, let me show you the proper use for this. So you won't injure yourself. You don't do a panic attack and scare the bejesus out of them. They're going to think you're crazy. Children show you when they're ready to learn something. And you guys, you want information, but you don't show that you're ready to learn. Don't you know these people got guns, tasers? They will lock you up. What you going to do then? Just because it works for him, that man has a reputation. Just because the things I do work for me, I have a reputation. Just because the non-guru, his stuff works for him, he has a reputation. If your paperwork is tight, you don't have to say nothing. For him, if your paperwork is tight,
Okay, we'll move on if you want.
Yes, please.
California, did you have a question?
I guess I'm the one unmuted.
Okay, great. Hi, Dallas.
Hi, how are you, Angela?
Greetings.
Hi, Truth. By the way, thank you for the Constitution, man. That was very good. Saturday, when I was on the conference call, I explained to you, Truth, about the case I'm going through with a traffic ticket in regards to the judge who ended up sticking his foot in his mouth and saying that he represented the people of the state when I said he can't represent anyone. Question I had regarding that, and that was a question I had for the Constitution man, but he had to go because of his phone. I know that in Black's Law Dictionary, it talks about the fictitious plaintiff. It defines that. Is there any case law regarding the fictitious plaintiff? And I'm asking that question mainly because the prosecution is the one that actually represents the fictitious plaintiff.
I'm not aware of any But this is the thing. The prosecution allegedly represents the people of the state, correct?
That's what I was told today by an attorney, and we had a kind of a long conversation about that.
Okay, aren't you a people of the state?
Well, depends upon what they mean by the people of the state.
No. Listen to what I'm saying. Aren't you a people, or are you a person?
Well, regarding fiction, I'm not a person, I'm a people.
All right, so the prosecution is allegedly representing the people, correct?
Allegedly, yes.
Okay, and you're a people. You could get 25 A peoples in there and stop the prosecution and say you're not representing the people. It's called a general populace. You can get 25 people in court to stand up and tell the prosecution you're not doing the will of the people and you're not representing us, and they have to cease and desist what they're doing.
If they ask me, well, where is that? What do you mean by that? And what do you have to document what you're saying?
Okay, this goes back to very old ancient case law. The 25% is the percentage that they use of the people. You know how they do the Nielsen ratings? They take a percentage to represent the majority.
Mm-hmm.
Okay, that's what general populace means. They're going to take 25 people to represent whatever the population is for that particular area. Are you following me?
Yeah.
And whatever the 25 people say, they're going to say, well, that's what the majority is. But general populace is such an old doctrine, you're going to have to definitely go to the library to find the book because it's an old book. It's a very old book, and it deals with city government. And you know they don't teach government in civics anymore, which is why you never heard of the term.
Mm-hmm. Okay.
It's been removed, out of the school books, and they're giving us the new stuff that they want us to learn. Well, if you really want to know real government, then you have to go to the library and get in the old books and get back to civics.
Now, what if you're up against a judge like I was up against last Wednesday, who was just totally obstinate, threatened to arrest me about 15, 20 times throughout the entire conversation I had with him, and so I had to be careful as to how I was talking with him and what I was asking and how I was asking things, because I was going through similar things like that, and he would ask me, well, what documentation do you have to support what you're saying and stuff like that, and some of the things I was going through was pretty much in estate paperwork that I turned in some time ago that I was just testing out in the beginning to see if any of that worked. And some of the questions they asked, well, what documentation do you have regarding your support what you're saying? And also with the document you're talking about, that book, is that something that someone has actually done in court so far that's worked very successfully?
I've actually done it in court before, the reason why I know about it. I did an affidavit of intervention, and I had 25 signatures on it, and I had them to stop a particular court case.
Okay. Okay, that makes sense. Okay. Something I want to comment on to the previous caller talking about, like you're talking about the asking them for their authority to act. About a year ago, 2 years ago, I had a creditor that kept calling me, the alleged creditor calling me regarding an account. And when I was asking them the question, the girl transferred me to the owner of the the CEO of the company. And when I asked him, I said, well, he was talking about this debt that I owed, and when I was going to pay it, I said, well, as soon as you send me a copy of your OID showing that you're the creditor and showing it on the debtor and a copy of the financing statement that you filed with the Secretary of State, then we'll talk. He hung up on me. I never heard from him.
Okay. Well, that's a good thing. But you said she transferred you to the CEO of the company. You don't know that. See, this is the thing. You was on the phone. How you know who you was
I
talking
have no idea who he was.
Okay.
But he's never called me since.
That's why we don't do things on the phone. You do it in writing. If you want to communicate, these people want to communicate with you, do it in writing. Because I can always disavow anything that was verbally.
You took the words right out of my mouth. Yeah. Nothing over the phone, period.
Okay, so I'm just letting you know. You need to stop answering. Write these people, tell them, anything, any communication, correspondence, let it be done in writing.
That's what I told them. I said, send it to me in writing. Send it in writing. They never did. They kept calling me. I said, stop harassing me, calling me. Fair Debt Collection Practices Act says, I can request that you stop it.
FCC violation also.
Yeah, and they kept calling. I said, so look, why don't you send this to me and I'll handle it in writing. Send it to me in writing and I'll respond to you. And I said, send it to me. They never bothered me.
Yes, that's an FCC violation. Guess what?
Yeah.
You could put the FCC on them for harassing you over a telephone.
And
that's a communications violation.
Yeah, I explained it to him. But the fortunate thing is, I haven't heard from them in 2 years. They haven't bothered me since.
Of course not, because they know they were fraudulent.
Yeah.
Okay.
So I just mentioned that something that actually happened for me.
Yeah. So that actually proves the point that when you ask them to prove their authority to act, you'll find that a lot of them will not be able to do so.
Now, we could go to the next call, and and I appreciate you calling in, and stop doing stuff and you have no witnesses. That was inappropriate for you to do that.
I had no one to go with me. That was the one big thing.
Well,
I had no one to go there. There was someone coming, but then they couldn't make it. So it's something I have to go through. Otherwise, they file a warrant for my arrest.
No, in California, you're allowed to do a trial by declaration. Look it up on the internet and find out the instructions. You didn't have to go to court. Ignorance of the law is no excuse on their part or yours. And if you had to did a trial by declaration, you'd have won the case. They never refute a trial by declaration. And that's done strictly outside of court. And that is unique for California.
I didn't even know that. See, I just learned something.
Yep, in traffic, if you get a traffic ticket, do a trial by declaration, California. I'm telling you.
I'm going to look that one up. All right, let's move on. Okay, Arminius, did you have a question for Truth?
Hello, Angela.
Hi.
Okay, I'm unmuted. This call just keeps getting better and better, and it's just awesome tonight. Hello, Truth. How are you?
Greetings. I'm wonderful, magnificent, marvelous, and splendid, evolving and progressing every day in every way. And you?
My question had to do with foreclosure, so I'm sure you probably really don't want to go into it. I'm in the process of writing an appeal right now on my case because basically they pretty much ignored everything that I did, the judge did, and let the defendants, I'm in a non-judicial state, let the defendants go for no reason at all, basically failed to state a claim where relief may be granted, and I laughed when I read that. But anyway, I'm in the process of writing an appeal, and the gentleman, the constitutional dude, he was awesome. But he went so fast through some of that stuff, I barely got very little of it in terms of the law.
The archives. That's how he talks in court.
Yeah.
I'm serious. When we're engaged in conversation, honey, have a recorder handy. That's all I can tell you.
Yeah. I plan on doing that, definitely. but I was wondering if I'm real interested in, just real quick, the denial of due process and discovery, because I was denied both of those in my trial. There was no hearing, there was no discovery, there was nothing basically. I wrote my complaint and a bunch of petitions, and 15 judicial notices and my list pendants and all this stuff, and then I did the petition to compel, and all together, 2 to 3 inches, a stack of 2 to 3 inches in this case, and I got nothing,
well,
except that.
In your appeal, you want to show the errors of the lower court, because that's the only thing the appellate court is interested in is errors. Mm-hmm. You can't put any new evidence into the appeals court. They're concerned about your due process. They're concerned about if the judge followed the bench guide. They're concerned about the rules of evidence. They're concerned that's what you bring up in the appeal. Every error that you can find in the transcript, that's what you put in your appeal. You put down where the error is. It's on page so-and-so of the transcript, and yada, yada, yada. That's the only thing the appellate court is going to deal with is error from the original trial court.
Okay, now something to add to that. Did you object to any of the violations in the lower court?
Every
verbally?
Single time with a judicial notice, absolutely.
Okay, you're good. Okay. Yeah,
yes, absolutely. And if this is who I think it is, I wanted to thank you too, because one of the things in my complaints that I particularly really liked was the truth on the federal truth in lending disclosure statement, where they tell you what the cost of your credit is, and of course the banks can't loan credit, and I really like that. So I wanted to thank you for that, sir. And I'm not going to go into it any further other than that. And I know there's lots of people waiting, so thank you all. It's been extremely enlightening tonight.
I just would like to add to that's in the National Banking Act. And I'm telling you, the reason you lose in court is because you failed to put the law into the case. If you had a copy of the law that they was violating and entered into the case, the judge cannot move around that fact. You have nothing in your evidence folder, so when he opens it up, there's nothing there. You're giving him discretion to do whatever he wants to do. But if you put the law in the case, in the confirming court case, just like the gentleman said earlier, you got Memphis Bank versus Tennessee that says specifically it's the supreme law of the land, and they took it out all of the books across the nation in 1984. If you put that Supreme Court case into your tax case, there's nothing they could do. It's nowhere to run and nowhere to hide, because he cannot go against the judiciary. It's already been adjudicated. It's fair decisive. It's res judicata. That judge will be committing suicide to go against the Supreme Court law. And that case is still good case law. Jeopardized it. It's not been overturned. But you need your own copy showing that you jeopardized it, because you can go into court and the judge can say, oh, that case has been overturned. And you could say, Your Honor, I believe that you're misspeaking yourself. I have a copy where I just recently jeopardized it, and this is still good case law. Like the gentleman said, be very, very polite. Show some respect. Act like you got some breeding. You can win more, you could draw more flies with sweet stuff than you can vinegar.
Okay, can we move on?
Yes.
Central Coastal California. Did you have a question?
Yes. How you doing this evening?
Hi, fine, thanks.
Good. There was a gentleman on earlier commented from Tennessee that was a veteran, I'm a disabled veteran in the Maryland area, and I experienced some things that I really want to try, and I put myself in a position to fight. First of all, it was a felony charge, and I was framed up on. Never had experience with the I guess criminal justice system of the corporate setting. I'm in a mode now to really stabilize myself to fight back and to I can start on the quest to correct my name and get this felony removed from my record. So I'm trying to just approach this in a steadfast way that would give me solid grounding in understanding my approach. And I do appreciate the repeated things, and I hear you loud and clear, Truth, that you definitely need to have grounded law in your pursuit of trying to rectify whatever you're pursuing. So that's where I am right now. I don't know much about UCC or even if it's necessary, but I am reading. I'm getting somewhat of a grounded foundation is just trying to incorporate every single thing that I can, just reference to learning. And this particular site has been very helpful. Angela's website, I've been on it. But my question is this. I definitely would like to merge my efforts and to understand how I can go about doing this with the assistance of some of the very valid points that the Constitution man brought about. And I do and would like to contribute to that computer process that's going to be acquired for him. I'd like to contribute to that as well as Angela's site as well. I came kind of in at the middle part. I didn't understand what was being said about the sponsorship, but if that's part of it, I'd like to get in on that. But I'm very interested in going forward and getting whatever suggested points that can assist me in my quest to get back on solid ground as an American citizen and to get this court system off my back. I'm currently in I did 4.5 months in jail, and I'm currently on probation. And this is something I'm really uncomfortable with because these people just sort of force something on me with a lot of trickery that I wasn't familiar with. And I guess in my listening over the few months, I understand a lot of people have been caught in that same situation. So I'm open for trying to get any suggestions that might be out there in terms that might assist me as well as others that are listening in terms of trying to clear these processes. So if you can give me some information, I'd appreciate that.
I would like you to email me. Let me know that you put a veteran in your byline so I can forward it to the Constitution man. And I appreciate your donation. And everybody who's making a donation to the Constitution man, when you go to Angela's site, email her and let her know that was for his computer. Those of you who are going to sponsor Angela, you don't have to put anything. That's to her. But if it's earmarked specifically for the Constitution man, please let her know in some kind of way that this is for the Constitution man. Okay?
Okay, so I would just note that perhaps in an email in her subject, in the subject line area, perhaps.
Right.
Well, when you do the donation, there'll be a spot. Wait a minute, no, I did mine a different way. That way she got the whole 100. Yeah, I don't know if you can do it off of her email, but there is a way that you can make a donation where you can let her know right in the the message, what it's for. But I don't think it's off the site, though. I did mine a little different. Excuse me.
Well, just you make your donation, send it to Ange, and then send her email. Say, I made a donation. This is for Constitution Man. I made a donation. This is for you. It's, no muss, no fuss. And make donation the byline.
Okay. This is not a problem. Now, one other question. Is this particular episode archived or will be archived?
It will be.
Okay, great, because I'd like to go back and capture some of the things. And one last question. I recently embarked on, I guess, doing the executive letter reference the post office and utilizing the United States Outline Minor Islands. I sent it to the Baltimore, Maryland postmaster, and I think I outlined the letter perfect, exact, just as the instructions noted. I got a call from the manager saying that she believes, without any fact, she believes that me occupying the office of executor was a fraudulent process, and they would not honor it, and they do not have a general post delivery. I didn't argue the point with her because I said I wanted to, I guess, get some suggestion as to what would be the next enforcement step that I need to undertake. Now, I did, make some notes on the conversation, but should I looking at the postmaster out of the Washington, D.C. area in terms of trying to combat this situation, because I think that I've sent mail through as test mailings, and I haven't gotten those. I went to the annex, which the mail should have came by way of general delivery, and me just going to receive that mail, and nothing was there. So any suggestions along that line, please?
Number one, you need a copy of the postal manual because there is such a thing as a delivery, and they have a card for you to fill out so you can get it. It's for transient people. They've always had it. You need to respond back to the manager and tell you thank you so very much for her concern about you, her believing that you might be committing an act of fraud, claiming the position of executor. However, this is above her pay grade, and she really needs to refer this to her legal counsel.
Okay. Well, I certainly appreciate that point. And I did alert her in the conversation that I had, she was on speakerphone, and there were two other individuals that, did hear a comment. And she got a little irate at that point and said, well, you better not be recording me. I said, well, I do have other people that did hear, your comment.
Now, hold up. You can record anybody that calls into your house. You have a right to record them. If they're calling into your house, nobody can tell you what to do with your stuff.
Right. Well, in Maryland, I think there was, I need to educate myself on that, but she basically was kind of restated her position after I stated I had two witnesses to say, well, at this point we won't be responding to you because I requested her to send me something in writing as to her decision, but I think I'll follow suit and be proactive and just send, that letter as a point of I guess, a strategy.
Right. Well, make sure you make reference to the telephone conversation that you had with her on such and such date, and you had two witnesses present, who's willing to do an affidavit as what she said under pain of penalty of perjury, and the fact that she's still above her pay grade. She doesn't have a classification for this. And things that's above her classification she does not know.
Right. Okay, well, I do appreciate that, and I look forward to, future communications on that. I appreciate and thanks for all the information that I've grown with over the last few months.
Well, don't forget to email me and put a veteran in your subject line, please.
Okay, I will do that. Okay, thank you.
All right, thank you. And we're going to move on to Iowa, East Iowa. Go ahead. East Iowa. Go ahead.
Hello?
Hello.
Greetings.
Good evening. I have a couple of questions. The first one is there a limit of time you have to file a complaint on officers that they're doing search warrants in my house, and I think they're breaking all kinds of laws, and they know that I'm a single parent. And the last one, they done 2 last year, and the last one was in November. And they steal things from me, and they don't write it down on what they take. The last thing that they took from me were a book of Red Fox stamps. And I don't think the search warrant that they left me, it says house copy, and it's a copy. It's not a wedding signature, so I think that they broke a lot of laws, but I was just wondering, is it a period of time that you'd have to file the complaint on that? And I was also wondering, can you write stuff like that into a security agreement and what?
Well, you're going to file a citizen's complaint against the officers, number one. And did you happen to get their name and badge numbers?
No, they do it when I'm not home. They do it when I'm not home, and this last time, basically they've been kind of harassing my son. That's kind of what it's been behind. My older son is in prison, and I don't know if they're targeting his brother or what, but basically it's always when I'm at work. And what they done this last time is they took him and put him in a room, locked him in a room downtown, and the police were still in my house. They did not call me and make me aware of anything. And when they finished, he said that he started knocking on the door down there because he said he didn't have a watch on. He didn't know how many hours they had him locked in this room, so that's an unlawful arrest. They didn't have any reason. And then once he started saying, you don't have a right to lock me in here and stuff like that, then they let him leave. And they just locked the door behind them when they left my home. They keep kicking in my doors and breaking my windows, all this stuff that they've done. And the first time I did file the complaint when they done it earlier in the year. And then they started harassing my son. They came out of the blue and just knocked on my door and started asking me what my son had on and how was his hair, and telling me an incident happened in such and such an area. And to me it was kind of like a warning to say, we're going to, be messing with him if you continue to mess with us, basically. So I didn't follow through with that last complaint, and then they come back in with another search warrant, and they're just taking things. And I'm so frustrated, but I'm feeling like we're being harassed, and I'm not sure how to handle it.
You feeling like you're being harassed? You are being harassed. If you don't have anyone, one of your neighbors that can video this, have somebody answer the door, take a picture with their camera phone or whatever, you need to rally some people together and catch them in the act and take their pictures.
Okay.
and you need to email me, and we'll address this in further detail. Because there is something you can do and file another citizen's complaint and list all the damages and everything that you're missing.
Okay. And now the one that I filed before that I let go, I was kind of fearful because my son, I didn't want them to mess with him. But can I go back and just add that into this one and go for it all? Because I'm really kind of fed up now because.
Oh, definitely. And you, there's a civil rights commission in your area. I will file a civil rights complaint.
Okay. Okay.
And like I said, if you belong to a church or any type of organization, see if you can get someone that has a camcorder or whatever, and have people sitting outside your son's school to see if he's being harassed so it could be filmed. You know what I'm saying? There's things you could do, but you need help. You can't do them alone.
Yeah. Another thing that you want to do is with regards to their authority to enter, you want to check all those, if they got the proper documentation that was signed by a judge that allows them to go into the house, and under what pretext. Because a lot of times you'll find out that they don't have the proper warrants.
Exactly. Make a copy of all of that and get it out of the house, because that'll be the next thing they'll come in to try to confiscate is their fraudulent warrants.
Yeah.
So make a copy of them and put the originals, if you have to go rent a safety deposit box or a post office box, or just don't have that type of information where they can come and get it and destroy it.
Okay. Yeah, because I don't feel safe in my home at all. And I take my stuff with me everywhere I go. Certain things, I take them to work with me. I take them anytime I leave because I don't know when they're going to come in again. I don't know if they made copies of keys. I don't know what they done while they were in my house. And
well, you can always change your locks. Look, this is a sister talking to another sister. Honey, when I couldn't afford to change my locks, I switched the front door with the back door, the side door with the basement door.
Mhm.
You can switch your locks around. So the front door.
I did on my front door, but my side door is like it's a sliding door, and I don't know how to do that one.
Well, ask someone. I'm telling you, somebody's going to help you. But I'm just saying, you have to do what you have to do. When you can't afford to change the locks, just take the front door lock and put it on the side door, the back door lock, put it on the front door. You just have to do what you have to do. You know what I'm saying?
Yes. Thank you.
You're welcome.
Okay.
But like I said, email me and we'll go into further detail. I can't give all my trade secrets out on the phone.
Okay. Now, your email address, where do I find that at?
On myprivateaudio.com.
Okay. All righty. I will do that. Thank you.
You're more than welcome.
Have a blessed night.
You too. God bless you. Any more calls, Angela?
Tell me we lost Angela.
No, she probably had to go attend to Joe.
Yeah.
That's the only time she leaves the controls, if he knocks on the door. I really do thank you for being able to participate in this call.
Well, thanks for the invitation. I should be able to make it a little bit more often now. My other obligations switch from Thursday to Wednesday, so that'll free me up. That's why I was able to make it.
Well, you know me. I be trying to know people, and I be out searching. I be out searching to find out, are you really who you say you are? And you know me, I got to have evidence.
Yeah, he's been around a long time, and
very long. and he's paranoid as can be. I'm telling you. So you have to respect that because he's a veteran. He's been they tried to kill him about 18 times. You can't mess with the man. He came back after serving our country, and the Vietnam War was the one we got our butts kicked. That's a war that never should have happened in the first place.
Right.
It
was a shame that because they were set up to lose.
Exactly.
They were set up to lose. Anybody knows history, they
all came back with such an Agent Orange. So he shared information with me about his personal health and I mean it's sad because I almost cried when he told me his physical condition because I got the opportunity to come into Michigan. It just so happened we had lunch because that's his favorite thing. He wants to meet for lunch, right? Mm-hmm. So, I mean, he was just in so much pain. There was nothing I could do, And he was just rocking and turning red and, you really wanted to help and console, but it was just absolutely nothing anybody could do.
Well, he's suffering from the effects of the war?
Yeah. He's had his leg broken out. I think. Oh, you asshole! He tells you that on. If you look at his YouTube video, he's been shot in the head. He can't drive. He walks with a limp. I'm telling you, he's in excruciating pain. He's on the real hard stuff, and he has to wait till that kicks in before the pain subsides.
That's really bad because that's those side effects is really, really bad.
Right, and then he got Agent Orange, so that's a lot to bear. So I feel, it's an honor and a privilege that, he felt that I was worthy to receive his legacy. Because I would hate for all that information, to leave here.
Yeah.
And this man, he's not scared of nothing. He's not afraid of anything. So
No, he went through his battles. He's been in and out of prison during his earlier tenure. He's been through it.
Right, and I have he just shared with me a couple of I have some physical copies of foreclosure cases that he's working on that he's won. So I have evidence of everything that he's not just talking. He's the real McCoy. He's the genuine artist.
Oh, no. All you got to do is follow up on some of the things he's saying because he's giving you the case law. He's giving you the approach. I haven't seen anything wrong that he talked about.
He kept saying, "You people in TV land." See, he's old school, and he's not used to a teleconference. So he kept saying, "You people out there in TV land."
I thought that was so cute.
Me too. He's just old school. If you see his 111-page tax letter, he said, "Man, if I don't sue you, God didn't make little green apples and it don't rain in Indianapolis." And I said, "Oh man, you got to take that out of there because, the people that read these letters nowadays, they don't know what he's making reference to." You know what I'm saying? He's old school, but he gets the point. He makes a comment, "Well, let's get down to the real nitty-gritty," I'm not making fun of him, but I'm saying this is the 21st century. We need to make the letters just a tad more professional. Because you are not him, and you don't need to be using words like that, and you in your 40s. You know what I'm saying?
Well, and that, not only that, any document that you get should be customized to suit you based on your knowledge base. Because if you can't explain what's in the document, you shouldn't be using it. Because you go into some of these courts now, the judge wants to know that you know what's going on, and you're just not pushing paper that somebody else put together. And if they can trick you into saying something that would defeat your own cause, which most people wind up doing, they'll do that too.
Right. See, our biggest problem is because we're so educated and literate, when you go in court and they say, do you understand? Yes, I understand.
Well,
No,
you just lost right there.
Right. You don't understand nothing. You know, don't ever understand. Why am I here? What's the charge? And how did we come to that conclusion? And who are you? That's our biggest thing. We fail to
I'm here. I'm here. How are you here?
Yeah, we fail to ask.
Weird.
Yeah. Well, that's what's going on since you stepped away and came back.
Oh, no. Yeah, my son's attendant left. I had to go run.
I know. I understand. Trust me, I knew.
Okay, well, I think I've taken care of the situation now. I just figured out.
Okay, so next question.
Hold on 1 second. The next question is Southern California. I'm trying to unmute him. Hold on. There's a lag in the board. It's not unmuting. There's a delay. And you know, Southern California, try pressing *6 when you're in there. I'm clicking it and it's not going away. The joy of TalkShoe. I love TalkShoe.
Hello?
Thank God for TalkShoe. Hello.
Hello?
Greetings.
Okay, I don't know if I'm Southern California, but I'm in Southern California. This is the computer man.
Okay, go ahead.
Okay, I'm looking for information that I can put together, I don't mind studying, to help me eliminate the deduction from my Social Security check by the Treasury, Department of Treasury. That I'd love to free up that money. I could make more donations.
It's not a problem. Just email me and put that in your subject line, please.
Okay, my whole thing is frozen here. Can you still hear me?
I can hear you.
Did you hear me?
Yeah.
Was you able
sure
to
you
hear
can
me?
still hear me?
Oh, and one more thing. If anyone needs any computer expertise at all, like creating automated forms, PDFs, and so forth and so on, please get in touch. That's what I can give to make the world a better place.
Okay, and you're the computer man.
Yeah, you know who I am, right?
No, I have no idea.
Friend of Norm's.
Oh, okay.
Yeah.
I know how to. I can route him right to Norm. I'm sure he'll be pleased.
Yeah. It's Lawrence.
Hi, Lawrence. Okay.
How you doing? Okay, thank you. That's all for me. I'm a happy man now.
Okay. Thanks so much. Okay, I'm trying to.
Oh, one more thing. I sent you a donation.
Oh, thank you kindly.
Well, I had to after these last couple of calls. It's just incredible.
Thank
you so much. Very much appreciated.
Okay, let me go. Bye-bye.
Okay. My board is totally frozen, so if y'all hang with me a few minutes. Did the announcement come on by any chance saying that the call was going to break down in 5 minutes?
No, it hasn't come on yet.
Okay. Go ahead and keep talking truth, if you don't mind, and you too, Harold. I'll be back as soon as I can get this straightened out.
Alrighty then. We appreciate it. So, anyway, I got the 4-page letter that the gentleman Oh yes, definitely got a freezer board. It's a 4-page letter to remove lien from the Social Security. So I can share that information with you.
Well, that definitely will help him.
Yeah. I've just been updating, you know,
My name is Elmo.
You know what I'm saying?
I missed a little bit of what you said.
I've just been updating the vernacular, the verbiage that's in the document.
Oh, okay.
Mm-hmm.
I wish I had more time because that's, you know, being that I'm also a writer, an editor. Just
well, yeah.
that for you.
These, you know, Just Dave, he's a writer, and he tells me he writes pretty good, so he shouldn't have any problem changing, you know, some of the verbiage.
Yeah, I've gotten a lot of good stuff tonight.
You get good stuff all the time.
I guess, yeah, I've been getting a lot of good stuff. Somebody's been Skyping me some stuff. Somebody needs to take their dog and put it away because they're being rude.
Right.
Yeah. I can hear you. You know, I've closed the browser and everything, and I'm still on, and I can still hear you. Isn't that funny?
Yeah, TalkShoe is really jammed up tonight. It's I've had a hard time here too.
It
doesn't like us
connected,
tonight.
But anyway, yeah.
The hardest time was for us to get on. Man, I've never had a problem getting on TalkShoe like I had a problem tonight.
Oh yeah,
I was really proud.
Yeah, so did I.
Yeah, I'm sorry. I wish I knew how to fix that, but
no, it's just probably too many people trying to get in at the same time.
Right, gridlock.
Yeah, so it was bound to happen. You know, because I don't know who this Angela Starkey is, but she's been having some pretty good guests on.
Yes, she has.
Some people, you know what I'm saying?
Yes, she has.
Yeah, she draws a crowd.
I couldn't have done it without you, Truth.
Yes, you could have.
Well, I would have never been able to reach our special guest tonight without you.
Yes, you would have. You just didn't put your feelers out. I happened to put mine out.
And yours worked.
Yeah, I had
long feelers.
Yeah, really.
Yeah, I had a special interest, you know, and I was kind of, my back was against the wall, and I had to deal with a criminal situation. I'm not experienced in that area, so I had to get somebody who knew how to, you know, navigate that water. And that's what I had to do, because like I say, when you start touching my family, you're kind of rubbing me definitely the wrong way.
Shall we take another question?
Of course.
Okay. Let's try it again. Trust law. Go ahead, Carlos.
All right. Good evening, everybody. Truth, everybody.
Greetings.
Okay. The attorneys, they want to dismiss my quiet title. Okay. I filed in state court. They moved it to federal court, which is fine. They wanted to dismiss it after they moved it to federal court. The judge did not let him. And I spoke to one of the guys that worked there, and he says, this is a real good judge. We became friends with this guy that works at the court. He says, this is a good judge. Most likely the judge did not have him dismissed or did not grant the dismissal because you have pretty good grounds. So he says, yeah, keep going, keep fighting. Now, I noticed I get another letter. I have a hearing on the 14th, but the attorney from Wachovia says that in that letter, in that motion to dismiss, he says he tried to speak with me twice. He says I told him I was busy. He in one occasion, in another occasion says I didn't have time. I would call him back, and he says he never called me back. At the third time he attempted to get in touch with me, I hung up on him. I don't have none of that recollection. I don't have none of that. All the recordings, when I get a phone call, automatically they are recorded. So what I'm going to do, I'm going to file. I'm going to get all the records from Verizon, which proves he never called, and also I'm going to charge him with mail fraud and do a power grievance.
You don't have to do that. Make him produce his phone records. You don't have to do that. Make him produce his phone. He said he called you. Make him produce the phone records.
Okay, that makes it easier for me.
Yeah.
Okay.
I mean, the burden of proof is on him.
Okay, good. That's why I'm here, Truth. Okay.
Well, okay, now, who's the plaintiff?
They are. I'm sorry. I'm the plaintiff.
He's the plaintiff, and the defendants moved it to federal court. Now, shouldn't, I don't know how, they can't be too bright now, can they, Harold?
No, because most of the quiet title actions that they try to do go straight back to the state. The federal courts don't deal with it for the most part.
But the thing of it is, now you get to put federal case law into the case that they violated and give the judge jurisdiction over a federal question, and it can't be moved back.
Right.
And then you may get a better shot, and especially where you're at in California, you might do better to try to fight to keep it there.
Right.
Exactly. I would be shouting. I would put the National Bank Act in, the International Banking Treaty of 1978 that they violated, and I would put in the fact that they violated my due process, the Fifth Amendment, and equal protection under the law. I will put in that they violated the Fourth Amendment, a right to be secure in my property.
Right.
And I would definitely put in my $1 million baby, Title 18, United States Code 656. That's $1 million fine or 30 years in jail in and of itself. I would do 3 separate invoices, one to the attorney, one to the law firm, and one to the bank. And then I would times that $1 million fine times 3 for the fraud and give each of them a copy. And I would keep it right there in federal court. The judge will not move it because you just gave him jurisdiction over it.
Right. And the judge, like I said, the judge is one of the guys that worked there says this is a good judge. He says he's fair. He says, and he didn't let him dismiss it, and he did not approve the dismissal because he knows you have a good case. So he says, keep it here.
Give him more to work with.
Yes. That's why I'm here. Truth. Thank you.
Put the law into the evidence file.
Right.
Give him something. He looked at that National Bank Act. Banks can't loan credit. They can't loan the depositors money. They can't loan from the capital stock. So what did they loan you?
They extended credit.
Well,
I just said they can't loan credit. That's the first thing came out of my mouth. That's in the National Bank Act. See, you can't say it. What law says that?
Right. No, I'm not going to say anything. That's what they're going to come back. But I'm just gonna fit in the evidence, what you're just saying, and be quiet. I'm not going to say anything. I'm just going to let them do the talking.
But you could do a notice and demand for out-of-court settlement and give them an opportunity to save face and settle non-disclosure under seal.
Right. That's. I'm going to do the ADR. They call it ADR. That's already applied for that. But my main question is this: should I just let them produce the record, or should I bother gathering the records and throw them in the judge's faces? Look, they are lying.
Are they the original lenders?
No, it started with Worlds. It went to Wachovia, and now it's Wells Fargo.
Okay, you don't have a contract with them. So what records do they have?
None.
Oh, okay. That's all I want to know. Where's the contract?
It's in Japan, probably.
No, you don't have a contract with them. You only have a contract with the original lender.
Yes, with World Savings. Right.
Okay.
Right.
So where is the written authorization? Anytime the provisions of a contract is changed, it has to be written authorization. Where's the written authorization to change the provisions of your contract? They have to have a letter from you in writing and notarized that you knew that they were changing your contract. That's basic contract law 101. They cannot change your contract without first notifying you, and you have to agree to it in writing. Anything dealing with real estate must be done in writing.
Anything over $500.
UCC law. Right.
Statutes of fraud.
Yes, sir. I learned that from you, Harold. Thank you. Yeah. Okay. Good thing. Good deal. I'm gonna give somebody else a chance. Thank you, guys.
You're welcome.
Okay, Dia, I know you got kicked off a couple times. Go ahead. Did you have a question?
Yes, I do. Can you hear me?
Yes, we can.
Okay. The question is, what's the difference in the Constitution between the capital C and the lowercase c in citizen?
There are three types of citizens. There's the state citizen. There's the United States citizen, and there's the 14th Amendment citizen that they created.
Okay.
The United States citizen as well.
Where's that distinguished in the law?
You would have to look it up in the... Everybody is a citizen, and you owe your loyalty to the state, not to the United States. As it was mentioned earlier on the call, these United States is not the United States. These United States, each state is foreign and sovereign to each and every other state.
Yes, I understand these things. I've been dealing with this for many years. I have not found one person that can either state it in a Supreme Court ruling, or in a congressional record where it clarifies exactly what the meaning of this is.
The citizens, trust me, there is Supreme Court law out there for it, and the fact that each state is foreign, there's a case law on that. The fact that your state is a nation in and of itself is case law out there on that. But
can you reference a couple cases?
I can't do it off the top of my head. My memory is pretty good.
Okay. Well, there's no standing there then. If there's no standing there, if you can't reference to a case, I've dealt with this many times, and I've had many people tell me that it exists, but when I ask them about it and I say, well, please state the record where it's at in the court case or in congressional records, I have found that no one can give a case. And another issue is when we're talking about all capital letters of the person or a citizen, no one can come up with any congressional records or case law where it states that a all caps name is a fictitious entity. I've found no one who can answer these. These are the fundamental basis of all arguments.
Well, okay. If you do you know Rod Class?
Or do you know Richard McDonald out of California? Go to state-citizen.org.
They'll take you all the way back to Roman time.
Yes, but that doesn't give you a court case or any standings here in what we're dealing with today.
Yes,
if we're going to resolve...
Why? Okay, excuse me, and I'm not trying to be rude. The information you need is in the law library, and you're asking someone to give you some information. If you would go do your due diligence, I'm sure you could locate it. But you cut me off, and I was going to tell you, I do have the court case. I just couldn't recite it off the top of my head, and then you said I had no standing. So now I have no reason to go through my archives and find you the particular court case because you already have your mind made up that nothing exists. So if it doesn't exist, I'm going to leave you to your belief. But I know better because I have the court case. I had to find it when I was in law school, which I went to 27 years ago. So, no, it's not on the top of my head. I would have to go back and look at my notes.
Well, I apologize if I came across like that, but I've been dealing with this for quite a few years myself. And
You
I
went
have
to law
never
school,
found...
did you? You did go to
Pardon me?
law school as well?
No, ma'am, I did not.
Oh, okay. I'm just asking.
Does that matter?
No, but I'm telling you I did. And I have the particular case because you're reminding me of something that we had to specifically define in school, the difference between the three citizens. You understand what I'm saying? I just don't remember where I have it because I save everything. I'm OCD about saving stuff. I just have to remember where it's saved at. Does that make sense?
Yes, it does. And like I said, I do apologize if I came across wrong here. I just wanted to be pointed to a particular case so I could review it myself. I don't have a problem with that.
If you can get, I don't know his website offhand, Rod Class, because between him and his brother, they did a lot of research in the Library of Congress. Because just like the Constitution man had stated earlier, some of the things they took out of the system that you can only get sometimes either in the grand universities or the Library of Congress itself. And he has a whole expose on that right on his website.
Okay.
So with the authorities and everything behind it. So that's
I used to do an affidavit back in 2005. My original affidavit to the IRS had the three citizens in it. And I'm telling you, I had the case law. But, that's been 4 laptops ago. And I don't have that information on this particular laptop I'm using today.
Oh, my
Conference
gosh.
is scheduled to be broken down automatically in
5
minutes. To extend the time by 60 minutes, press *8.
I cannot do, but I wanted to tell the gentleman that I have a link to Rod Class's documents on the website, myprivateaudio.com, and it'll take you to that race servers where he stores all of his stuff.
Actually,
I know that.
Actually, he's got about
Rod's
3 sites.
I know that Rod's working on the strawmans, and that still hasn't been defined yet. No one's really defined the strawman and being able to prove exactly how they did it and to be established this in courts. That is non-existent, period. I've not found that from anyone. This is a very important...
I don't agree because you look up the definition of straw man. You look up the definition of putting a nom de guerre in all capital letters. It represents a deceit. It represents a person. A corporation is fully there, which is a deceit. And a corporation is in law referred to as a person, which is imperative. Like you refer to yourself as a people at all times and not a person, as not to get confused with the straw man, which is a trust that they created in the all caps name.
Well, how would you be able to prove the bonds are issued on that? Because I have found nowhere where they can prove that the bond's been issued on the strawman.
Yes, my birth certificate is on bond paper, and it says it's void and it's non-negotiable. Your birth certificate is on a bond itself, and mine tell you it's a bond. It's on bond paper, and it says not negotiable. It's void. Your birth certificate isn't like that. Mine is. Mine is a bond on bond paper, and it says it's non-negotiable.
How do you get the bond number?
It's on. They put it on my birth certificate.
It's on there. It's right on there.
When you get a copy of your birth certificate, the bond number is there.
And
well,
what number is it exactly that you're looking for?
I'm sorry, I didn't hear you.
What number are you specifically looking for on there?
The one that represent what state the bond was issued from.
Are you talking the file number?
No, my file number is incorporated with the bond number. My file number, number one, my file number is on my county birth certificate, which is incorporated in the number that's on my state birth certificate, which is another number.
Okay.
So maybe in his state, I don't know where he is, it may be different, but my particular birth certificate is on bond paper, and I could go on Fidelity.com and tell you exactly what my bond is being traded for and everything. I've done that before.
Yeah, I traced mine too.
I have not found that on mine.
Well, right now you may not be able to because they kind of cut off the access, the free access.
Right, they changed the website.
Yeah.
Yeah, because I'm in Colorado and I don't find it, and not on my documents either. So I'm trying to figure this out.
There is a number on your birth certificate. Mine is up by my name.
Okay, I'd just like to say one thing. I love everybody. I love you. If the call cuts out, it's because it's over, and the archive will be up shortly. Good night, Truth. Good night, Harold. Good night, everybody.
Good night. Love everybody. My arms have stretched east and west. I love you guys this much.
I love you too.
Okay.
Go ahead and continue talking until it ends.
Good night, Angie. Thank you. Thank you,
Good
Truth.
night, Dave. Thank you.
Harold.
You're welcome. You're welcome. So what we're trying to say is email me because your experiences are not accurate. How about that?
Hello? That's fine. I appreciate it. I appreciate all the help that everybody has given on the call as well. I'm just trying to figure out how to get a hold of this number and then be able to go and prove it in court if I went into court, and to be able to show that there's a bond on this to claim back my property.
And the fact that it belongs to the decedent's estate, the state of Colorado